Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and the Shakeouts. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends. Just another manic Monday. It's just another manic Monday, April 27th, 2026. It is 4:30 here on the East Coast, and it's a beautiful day. Not a cloud in the sky. High 60s today. So I made the executive decision to push the show to the afternoon. And here we are. I spent the day outside because it's beautiful. Hello. Can you say sweep? Can you say sweep, Scott? Yeah, that's right. Colorado Avalanche swept first round of the Stanley Cup playoffs. And for those of you who celebrate, hockey playoff season is my favorite season. Scott, I should have bet you $100 because Scott, moderator, 25 years on the job, said, no way they're going to sweep. No way they're going to sweep. Let's see some brooms in the chat. Can we see some brooms? Yeah, the Bruins kind of, Bruins yesterday were brutal. Sorry about that, but let's hope. That's why I'm wearing this hat today. Let's hope that the Bruins can I don't know, win the next 3. They would need to win the next 3 in a row. The Bruins need to win the next 3 in a row to win this bracket. That's what they're going to need to do. Tonight, I told Scott I'd be done in time. Flyers, Penguins at 7. And we have a mutual hatred for Sid Crosby, although I still am going to root for the Pens. And we have the Golden Knights versus Mammoth at 9:30 Eastern. And, because John Tortorella is the coach now for the Vegas Golden Knights, I got to go with him. What are you doing on that one, Scott? I know you're an Islander fan. I'm a Ranger fan. Really one of the only things that we disagree on. But as I say, when the Rangers suck, as they did this year, I will then root for the Bruins. So, yeah, I don't know. That's right. Scott says that playoff hockey is the only sport you can skip the whole regular season and just watch the playoffs. Yep. And then I think I'm gonna, on the other side of the bracket, I'm gonna go with the Anaheim Ducks. We got any Ducks fans in the chat? And of course, I'm going with Colorado. And then when it comes to Tampa Bay and Montreal, I'm going with Montreal. I'm going with Montreal on that. Any Montreal fans in the chat? Some of you are like, can you just get to the point already? Can you just get to the point? We want to hear about Kelsey FITZSIMMONS. I chit chat with you because it gives time for people to come in because nobody's getting their notifications anymore because YouTube decided they're not going to give notifications anymore. And so it's a hard knock life. It's a hard knock life. for us. It's a hard knock life for us. Yes, this is ice hockey. My fellow Brits in the chat who are confused. This is ice hockey. It's the NHL. It is so exciting. Hockey, see, there's nothing like hockey. I'm sorry. I just don't like basketball. I can't get into it. I also like, as a New Yorker, you're sort of born into a baseball family. Tell me if I'm wrong. I was born into a Yankee family. And so I am a Yankee fan because you're born into your baseball family here. You don't switch. Whatever you're born into, that's what you're born into. I guess that Scott was born into a Met family, and I think you root for the Mets, right, Scott? And other New Yorkers, if you're in there, tell me what family you were born into, and tell me I'm wrong. And I was also born into a Jets family, but that was back in the day when the Jets played at Shea Stadium. Now that the Jets and the Giants are in New Jersey, it's like, who even has time for that? Who even has time? Getting to a game is the biggest pain in the ass. There's no easy way to get there. There's just no easy way to get there. There's just none. None. Oh, we got Yankees fans in here. And look, Scott's proved me wrong. He said, I was born into the Mets and the Jets, but I switched to the Yanks. And tell me what a pain in the ass it is now to go to a football game in New Jersey. I'm just not doing it. I'm not going to sit through 3 hours of traffic each way or more to go to a game when the Jets suck. So the Jets and the Giants also play at the same stadium, which is weird. I don't know if any other state has that problem. But we have that problem. It's a problem. Sorry, Buffalo, but you're out. You're out. Somebody says, ice hockey? I hate ice hockey, but where else is it played besides ice? Well, there's roller hockey. There's roller derby. I don't know. Field hockey, street hockey. It was a Brit who asked. So thanks, Flummixication. Tomorrow, there's a Kelsey FITZSIMMONS hearing on all these crazy motions that we've been seeing lately about allegations of, bad things about Kelsey, bad things about Justin. It's going to have to do with custody, and it's going to be tomorrow. But wait, because right as I was prepping this show, I mean, you may think it's really easy because I make it look really easy and that I don't prep for these shows, but there's a lot of preparation that goes into these shows. It's not like I just come on here and the 5 hours I spend with you is the only work I do. I do a lot of work behind the scenes, but somehow I missed this because I was prepping for today's show. And as such, this was sent to me by many of you. So thank you so very much. Hold please while I get it ready, because this is excellent, excellent, excellent news. And this was posted by Justice for Kelsey FITZSIMMONS. It says, breaking news, after 298 days apart, Kelsey FITZSIMMONS was finally able to see her baby boy, Caden, on the 25th of April, which would have been 2 days ago on Saturday. The visit went incredibly well, and he was so happy to see his mom again. So that is very exciting. It's going to conflict a little bit with the papers that I have for you today, but I guess Justin just finally caved, and Kelsey was able to see her baby boy this Saturday, 2 days ago, and the visit went incredibly well. He was so happy to see his mom again. There's a picture posted with this. I'm not going to show the picture because I know that Justin does not want Kelsey to be able to post any pictures of the baby anywhere. And so I am not going to, even though it hasn't been ordered yet, I'm not going to run afoul of those rules and then have to take the entire show down because I made the mistake of showing a picture of the baby. But the baby's beautiful. The baby is beautiful. His name is Caden, and I'm so happy. And look at all of you crying in the chat. You know why? Because you guys are empaths too. You're empaths too. Sweet, right? Isn't that exciting? I don't know why Justin changed his mind, because we're going to read an opposition to the motion today from Kelsey, written in the voice of Kelsey. He is now, let's see, his birthday is in February. So he is 14 months, a little over 14 months of age. Can you imagine? 298 days apart. That's almost a year. Yeah, I think that too, because there's a hearing and maybe he wants to come in and say, oh, I've been cooperating. What do you mean? I cooperated. I'm cooperating. Look at Shop and Tan for me with your 20. Thank you so much for your super chat. Says, thank you for all you do. Is Damages a TV series? Yes, Damages is a TV series. Here she says, I looked for a movie and I got a series. You are the greatest. Yes. It is one of my favorite lawyer shows of all time. It is with Glenn Close and Ted Danson and Rose Byrne. Rose Byrne is amazing. Here's the log line. The log line is a law school graduate becomes the protege of a successful high stakes litigator. Glenn Close is chef's kiss. Amazing. 59 episodes. It ran from 2007 until 2012. It originally aired on FX. I'm not exactly sure where you can watch it now, but highly recommend. It's 59 episodes. And it's riveting. It's amazing. For those of you who love damages, let me know. Thank you so much. You're 20. Thank you, Shoe Kindness, for becoming a member. And Can't Win says happy Monday to me, Mods and Fellow Cupcakes. Thank you for being here for 5 months. Thank you for the peace sign, Lisa C. And for being here for 26 months. That's a long-term relationship if I've ever heard of one. Overruled Sit Down said I was born into a Yankee and a Steelers family, but I'm going with the Lightning. All right, I'll allow it. Got to have something to root for, right? Martina, thank you for your super sticker from New Zealand. I appreciate you so much. And Nona 3 says happy anniversary to us, and I'm so happy for Kelsey. Oh, thank you, Nona 3, for being here for 7 months. And it is very exciting, isn't it? We've been waiting for a long time for this to happen, and it's really, 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 really good news. We've been here since maybe 11 days after Kelsey was shot. I've been covering this case all the way back in July 2025, and we've been here for it all the papers, all the motions, the trial. We watched her acquittal. It has been a long road, and it's still not over, because now Justin and Kelsey are fighting over custody. And so we're here for that too. The hearing's going to be tomorrow morning at 10 a.m. I will be covering it for you live. So after this is over, I will teleport you to the morning stream so that you can set your reminder bell to come back, because you might not get it from YouTube. Janine says, I love damages. I was hooked after the first episode. Yep. Robin J says that. Glenn Close terrified me as Patty Hughes. I mean, really, what an amazing performance. It won a lot of awards. That show won a lot of awards. Yeah, it's been a long, strange trip, says Julie. A long, strange trip. When is the trial for Aaron Spencer? That is happening in June. Well, it is supposed to be, as of right now, June 22nd. I don't know if that is going to change. There is a hearing on Thursday, the 30th at 11 a.m. We still don't know if the new judge, Judge Wilson, is going to allow cameras in the courtroom. So I don't know that that's going to be televised. So we're going to see. I can't spoil it for you, Martine from Spain, because I don't even remember what happens in it. I just remember how much I loved it. Oh, please. I think people do go to family court. I don't know. If you guys in the chat, if you're going to family court, you can let Julie H know if spectators are allowed. This is going to be tomorrow's hearing is in Lawrence, right? I think it's in Lawrence, and it's a new judge. I had the docket up, but it just, for some reason, Judge Elwick is no longer on the case, and I don't know why. All right. Yes. Maya Miete in San Diego. We are waiting to see if it will be televised. There's a motion out there to disqualify the DA. So that might be pushed. There's another trial starting tomorrow. Let me just tell you what it is. And let me know if any of you are interested in it. It's a horrible case about a child. And I hate those. You know, I hate those child cases, but I don't know anything about this case, and I don't know how long the trial is supposed to take, but the jury is picked, and the name of the case is Wisconsin versus Josie Dykeman. Wisconsin versus Josie Dykeman. I just don't know. I apparently was supposed to start today. Now it's going to start tomorrow. I don't know how long that trial is supposed to be, because we did want to cover Caleb Flynn, if that is starting on May 4th. I don't know if they're starting jury selection on May 4th. I don't know. Tell me if you're following the Julio Fulio trial. Anybody? Anyone? I have not been. And because there are so many defendants, I thought that was going to be a really long trial. That would be too long for us to cover. But if anybody's following it and it's interesting, let us know, because I'm always interested in your thoughts. Always. Oh, Eileen is crying happy tears for Kelsey and her son. All right. Oh, I'm not going to yell at you, Mitchell. Don't be silly. You want to do the affirmation? What about the empowerment card? Well, let's no, we have the motivational. We used to have badass affirmations, but now we have a motivational daily calendar and empowerment cards. So yes, Mitchell, I will allow it. Today is Monday, April 27th. We do this every day that we're live because we have a motivational daily calendar. And who doesn't need a little motivation? I know I do. All right. Jack Welch is the quote of the day. Jack Welch. It's funny, Mitchell. Somebody wrote me a long email to tell me, I really like your show, but, whenever they say, I really like your show, but, the person said, you ignore anyone who doesn't pay. Like, I ignore anyone who doesn't. I don't even know what that means. Like, tell me I've been watching you from the beginning, but I think it's so rude how you ignore anyone who doesn't pay. Like, Mitchell's not a member. Mitchell didn't pay to say, Melanie, please don't yell at me, but affirmation. So I don't know. People are ridiculous. Why do people do that? I don't know. But it's like, whatever. Here it is. Jack Welch. Before you become a leader, success is all about growing yourself. After you become a leader, success is all about growing others. Oh, isn't that great? Before you become a leader, success is all about growing yourself. After you become a leader, success is all about growing others. Jack Welch. See? Winners focus on winning. Losers focus on winners. Here we go. There we go. And there we go. Shout out to Law Girls Not Attorneys who are going to be in court tomorrow. They do it all. I did get your email. I haven't had a chance to respond to you yet, but I don't really know what kind of, I don't really know how to answer that question that you asked me, but I don't know where that is. Law Girls Not Attorneys went by. Also, congratulations on your new grandbaby. It's beautiful. Thank you for sending me the pictures. But because you and I have different YouTube models, I really can't answer that question for you. I mean, anybody who asks me YouTube advice, I just got like thrown into the fire and I just do it. I can't really I don't really have any advice. There you go. Law Girls Not Attorney. Attorneys are going to be in court. And she says that's not true at all. She doesn't ignore people who don't pay. I know. Thank you. Thank you, Cheech. All right, let's pull an empowerment card because we do that too here. Because we all need empowerment in addition to motivation. Here they are. We're getting to the bottom of the deck. Everyone give Law Girls a sub and a like, because they travel. They get permission from the court to stream things that we can't stream. And little Law Girls getting quite an education being homeschooled and going to court every day. I think that's fantastic. I'm a big fan of that homeschooling model. If you're going to rise, you might as well shine. If you're going to rise, you might as well shine, everyone. Remember, be sparkly. Don't ever let anybody steal your sparkle. That's not what it says. I'm adding that. But it says, if you're going to rise, you might as well shine. That's right. Be sparkly. Don't ever let anybody steal your sparkle. Also, I don't know. I don't know. Will they let her in this time being a minor little law girl? I don't know. We'll figure it out. I mean, I guess I'm sure they'll figure it out. Okay. The other thing I was going to say is, our friend Kathy over at Gossip Rumor and Innuendo, who we love so much, our paths crossed during the Brian Camp trial. That's how I found Kathy, from Gossip Rumor and Innuendo, and I was in love with her because she's so funny. Every morning she drops a funny recap of a trial from the day before, and it's short and it's hilarious, and I love her so much. Her YouTube channel got hacked. And I don't know what's happening, but hold on. I don't know what's happening, but hopefully she's going to get it back. So she has a backup channel right now. So if you wouldn't mind later or now, if you close out and get on over to gossip, rumor, and innuendo and sub up to her backup channel. Oh, here's what I will tell you, law girls, not attorneys, and any other creators that are in the chat. I get a million emails a week from alleged companies that want to sponsor me and do a product placement thing on my show. And they always come from weird emails out of the country, and they're very strange. And they're like, say yes if you want to, and we think you're a great fit for our product. That's what happened to Kathy. And she went through the whole rigmarole, and then she must have set up some sort of an account. And like 10 minutes later, she happened to be in a meeting, so she didn't see it until like 45 minutes later. Her everything was hacked into. So do not, creators, click on any of those phishing emails that they send to your YouTube email asking you to thinking you're a great fit for their product, because that's what happened. And I always had my suspicions about those things, but now I'm going to tell you, free advice of the day: don't do it. Don't click on it. Don't do it. Yeah, I know. It's horrible. All right, let's go to, as a Ranger fan, I can hate Sidney Crosby. That's me. As a Ranger fan, I hate Sidney Crosby. I did say that I still am rooting for the Pens regardless, because he's too good. That's why. He's too good. I mean, that's why. Yes, do not click on those things. All right, here we go. We are going to Kelsey's clapback to Justin's motion for temporary orders, which we read a couple of weeks ago. And we are now, Kelsey is clapping back with some new information. Settle in, get a drink, hydrate, because it's 25 pages, and I'm going to read every single page, and some of it is single spaced. So we're in it for the long fall. Did her bank get hacked too? Oh, Lisa, and I hate to hear that. Scott says, I've hated Sid since 1989. Thank you. It's Wonderskin. They do not sponsor me, but they should. It goes on purple. You wipe it off, and it's a lip stain that stays on your lips all day long. I think this color is XOXO. That's what I think it is. I will link it to the stream so that you can get it yourself if you like it. And if you use Wonderskin, let me know. Am I going to read the footnotes? Yes. What do you think this is? Some two-bit amateur operation? What if anything do you think it is that I do here? I watched episode 1 of a new Steve Carell show. Did anybody watch that? I think it's on Apple. Hold on, I'm going to tell you what it's called, because I haven't decided if I'm going to move on to episode 2. It's called Rooster. Anybody watch that? And Steve Carell is he's a writer, and his daughter's a college professor. Has anybody watched it? Well, what is it that you say you do here? Remember, one of my favorite movies of all time is where that line came from, Office Space. The guy who said that line in Office Space is in the sauna with Steve Carell in episode 1 of Rooster. So there's that. I'm like, where do I know that guy from? It's on HBO. I don't know. You guys try it. I don't know if I can move on to. Should I keep going? Laura W. from Chicago. Should I keep going? Wendy, you only watched 1 episode 2. Not sold on it yet. No, like I started watching Margot Has Money Problems because it's great. Because if you watch The Madison, Michelle Pfeiffer is also in Margot Has Money Problems, and she plays like kind of a little bit of a trampy mother to Elle Fanning, and it's hilarious. So it's a different character for her. So that is interesting. I have such limited time that it's like the limited time that I have needs to be spent on watching something really good, like The Testaments. Is anybody watching The Testaments? It's the follow-up to Handmaid's Tale. Hannah's in it. They're at the school with Aunt Lydia getting trained how to become wives. It's very interesting. Very interesting. The Testaments. Oh, Brittany, you're watching it too. You like? So earlier, Brittany, this is funny. This is kind of funny. Scott sent me a text that was meant for you. And so I wrote back. I knew it was for you. And I wrote back to him. I said, "It's me. Hey, I'm the problem. It's me." And he wrote back and he said, No, you're not a problem at all. Like, Scott, it's a Taylor Swift quote. I said, Brittany would get it. Brittany would get it. That's funny. That's funny. Oh, your friend did the costuming on the Testaments? So well done. La Misa, Filipino Food Club. The costuming, the wardrobe is amazing. I love it. Cinematography on point. If anybody watched the latest episode, the scene from overhead when they do the dance and they have the greens and the purples and the pinks all dancing and they show it from above. On point. Those costumes are on point. Great job. Great job to have. The dress, all of it. Fantastic. All right, let's get to the papers because it's going to be long, but I was giving you a chance to, get yourself something to drink. Don't say I didn't warn you. Okay. New filing just this morning in the Probate and Family Court Division. Justin Elaine versus Kelsey's FITZSIMMONS. This is mother's verified opposition to father's verified motion for further temporary orders. Now comes the defendant, Kelsey FITZSIMMONS, hereinafter mother in the above captioned matter, and opposes plaintiff Justin Elaine's hereinafter father verified motion for further temporary orders, hereinafter verified motion dated April 3rd, 2026 as follows. And we did read those papers. I've linked it in the, don't go off subject here because then I get distracted. I've linked it. I think it's still pinned to the chat. Justin's original motion is also in the show notes below the video, as is Kelsey's Give Send Go fund. Because good legal representation is very, very expensive. And she's got a fight ahead of her. It would be great if they could agree, but they're not going to agree. I don't think Justin's ever going to agree, even though he did let her see her baby see her baby on Saturday, and apparently it went well. All right, let's see if I can just... Introduction and relevant background. The parties were never married, but have one minor child together, Caden, born February 2025. The parties resided together between March of 2024 and June 27th of 2025 at 125 Phillipsbrook Road in North Andover, Massachusetts, the home owned by the mother. On or about June 27th or 28th of 2025, father voluntarily vacated the North Andover home, leaving mother with their infant son, then 4 months old, until June 30th, 2025. That was the day of the shooting. Mother is now residing at an address that I have redacted because there are crazy folks on the internet. Mother has paid a full year's rent for stability at this residence for herself and the party's son. This home has a full bedroom for their son, decorated and designed just for their 14-month-old baby. See Exhibit A. Father currently resides at the child in Stowe, Massachusetts, where he resides with his parents and has no residence of his own. It is unknown if Caden has a room of his own. On or about November 7th of 2025, mother sold her home in North Andover in order to afford legal fees for her 2 pending legal cases and to pay for costs associated with her son that she willingly wanted to provide. Mother agreed to put $50,000 into an account for the child, from which father withdraws funds to receive child support and mother's share of the child's uninsured medical costs and agreed upon activities. Said funds were deposited into an account held by father's counsel, and said account is being utilized in that fashion. Said plan was created during a time when mother was in custody and unable to readily access her bank accounts, readily receive communications about their son, and readily assist in decision-making for their son while mother was in custody. All that has since changed, but the order remains in place for the time being. What she didn't say, and what we know, because we've been following this from the beginning, is that Kelsey had to sell her home to pay her lawyers. We know that. And originally, Justin made a motion to the court that he wanted all the proceeds of that house to go to him for future child support. He wanted it all. That's when I started calling him just in it for the money. Because I always say to you guys, follow the money, follow the money. He wanted all the proceeds from the house. And the parties agreed, they stipulated to put $50K in escrow. And he only gets something like, what is his child support? I don't remember, it was $14 a week or $28 a month, whatever the minimum was, the mandatory minimum. $48 a month, maybe. I forget. Father is employed as an EMT firefighter with the North Andover Fire Department and is currently on administrative leave. There has been no update to his financial statement or discovery to know what type of leave, how long, and whether it's paid or not. $12 a week? Thanks a lot, girls. Yep. Thank you very much, Scott. Also, do not defame anybody in the chat. Do not dox anybody in the chat. Do not contact any of the parties to this litigation. Do not put drug names in the chat. Many creators have been struck, even for, a lawyer in court waving a firearm around. And you're not risking my channel because you want to put comments in there that are not appropriate for the tubes of you. We have to play by their rules. Not my rules, their rules. Mother was formerly employed as a police officer at the North Andover Police Department. On July 14th of 2025, Mother was placed on administrative leave and she resigned in December of 2025. Okay. No spoilers, please, because many people have not read the papers yet. Thank you, Law Junkie 33. So she resigned in December of 2025. I don't know that we knew that. Did we know that? We weren't sure about her status. But apparently she resigned. Kelsey did, from the North Andover Police Department in December of 2025. Remember, she was released from jail 2 days before Christmas. Mother is not currently employed. We did watch one interview with her where she said she might go back to law school. All right. Although Father obtained a 209A abuse prevention order against Mother on June 30th of 2025, that's the one that led to her shooting. That's the one they were serving on her when she was shot by Noonan. Father has since dropped the portions of the 209A that are in any way related to the child, including contact and custody. Father has also dropped the stay away and communication provisions between the parties. The ongoing provision is a no abuse provision, which the parties have agreed will remain in place for 3 months, after which time, presuming no violations, the entire 209A will not be extended and will be vacated by operation of law on the return date on July 13th, 2026. That was, I think, during the hearing in front of Judge Black, the last hearing that we watched together. It was Mother's choice to enter into the stipulation of April 14th of 2026 rather than continue to fight with Father in court and force the parties to engage in additional litigation against one another right when they need to be co-parenting for the sake of their 14-month-old son. I've been saying that all along. It is so much easier if you can, and you are in family court or divorce court. It is so much easier and better for all parties if you can agree, instead of letting a judge who doesn't know anything about your family or your family's financial situation decide your family's financial and custodial future, if you can. The day after Father initially applied for the 209A on July 1st of 2025, Father filed a complaint for custody support parenting time pursuant to Massachusetts law. Father amended his 209C complaint on August 8th of 2025. Mother answered the amended complaint on October 22nd, 2025, which included Mother's counterclaim. On June 30th, 2025, during the service of the 209A on Mother, Mother did raise a gun to her head in, quote, an acute transient psychological crisis, end quote, citing the report of Dr. Zeisel. Okay, there's an admission here, and she also admitted it in open court during the trial on the stand that she raised her firearm to her head. According to Dr. Zeisel, it's an acute transient psychological crisis. Her whole world came crashing down on her in one moment when she faced the loss of her newborn son as he was being taken from her right in front of her eyes, loss of her fiance, complete betrayal by the man who was supposed to be her support partner and future husband, potential upcoming loss of her job due to the 209A, loss of her home if she could not afford it once her fiance left, and loss of her life as she knew it. Due to raising a gun to her head, she was shot by a fellow officer. Okay. Also not fair to compare me to other creators. Not fair to them, so I deleted that. Thank you for your thoughts, but not cool. It's not cool to the other creator if you say something like that. You know what I'm saying? Due to raising a gun to her head, she was shot by a fellow officer of North Andover Police. Mother was immediately transported to Massachusetts General Hospital, where she spent 53 days recovering until she was transported to the Western Massachusetts Regional Women's Correctional Center after having been charged with 1 count of assault by means of a dangerous weapon in the Lawrence District Court on July 3rd of 2025. On March 12th, 2026, even before the trial on the underlying criminal action, the Superior Court, Judge Karp, issued an order, footnote 1, which just says, see the Commonwealth v. Kelsey FITZSIMMONS. Here's the docket number. Judge Karp issued an order amending the conditions of mother's release as follows. Inter alia means, among other things, that is your Latin lesson of the day. Inter alia, strike requirement that she reside with her parents, strike requirement that she stay away and have no contact with her child. On March 26th of 2026, Superior Court Judge Karp found mother not guilty of assault by means of a dangerous weapon. We watched that together and we cried collective tears. Months prior to that verdict, however, the parties had entered into a stipulation on October 21 of 2025, wherein, for purposes of this opposition, father would have sole legal and physical custody of the party's son. At that time, however, mother was in custody, had no ability to communicate with father, given the Superior Court orders and the 209A that father had obtained against the mother. As such, mother had no choice but to agree to those conditions or make futile arguments at a motion hearing, wherein the court would have clearly granted father sole custody at that time based purely on circumstances, as decisions for the child needed to be made without being hampered by lack of communication between the parties, given that mother was in custody at that time. And she faced criminal charges with no trial date set at that time. Mother was also still recovering from almost fatal injuries. RN2 moms is like, yeah, we were actually, we were all crying. Thank you, Gen X. I am so happy for Kelsey. And we read that stipulation, and that is exactly what I said to you, is that it's always better to agree if you can. Thank you, Charlie, for your Australian super chat. It is great news that Kelsey is seeing her baby. Here we go. Or did see her baby one time. On March 10th, 2026, mother filed a motion for further temporary orders and an affidavit in support thereof, hopefully anticipating the criminal trial's not guilty verdict and wanting to move forward with a co-parenting plan. Footnote 2, which reads, the hearing on her motion was initially scheduled for April 2nd, 2026, but given the criminal trial was not scheduled until March 23rd, 2026, and opposing counsel was not available on April 2nd, the hearing was moved to April 23rd. The court informing counsel and parties that this matter would be moved to Lawrence before Judge Ulwick moved the hearing to April 28th. That is tomorrow, and we will be covering it tomorrow live, starting at 9:45 because the hearing is scheduled for 10. Paragraph 16. Now, there have been substantial changes in circumstances since that stipulation of October 21, 2025, which mother seeks to address and modify the existing temporary orders for access and decision-making authority with father relative to their son. A, the Superior Court restrictions relative to the party's son were vacated. B, mother was found not guilty of the charge against her. C, the 209A order no longer restricts the party's communication or the contact with the child. And D, mother's mental health is stable and she no longer suffers from postpartum depression. To me, D, and proof of D, that Kelsey's mental health is stable and that she no longer suffers from postpartum depression, to me, that is the most important part. The most important piece of this, because I don't think anybody wants another Lindsay Clancy on their hands, any judge, any attorney. Kevin Reddington represents Lindsay Clancy, and it's horrific what Lindsay Clancy is going through. Nobody wants it. It's already happened in the Commonwealth once, at least, and so they need receipts on that. Apparently, they have, Judge Zizell, but let's keep reading. 17, father's response to his mother's motion, was not to attempt to reach any reasonable agreement, but rather to file his own motion for further temporary orders, vitriolic in its allegations, and spewing a clear inability or desire to co-parent, and a motion for a guardian ad litem. As is alleged herein, it is father who cannot co-parent with mother, and he creates a narrative around mother's brief 2025 postpartum struggles in order to still keep her away from their infant son almost 1 year later. Nothing can be more egregious at this point, and nothing speaks more than a father who cannot share custody or parenting time with a mother who has not seen her infant son since June of 2025. Footnote 3. Oh, here, it's in here. It's in the papers. Okay. On April 25th of 2026, which was 2 days ago, father allowed mother to see Caden for 2 hours at his attorney's office, supervised by the father and father's attorney. He is not allowed other contact or communication at any time. Well, here's what I think. I think that Justin's lawyer was probably like, listen, Justin, we have a hearing coming up on Tuesday, and so it would be in your best interest to allow Kelsey to at least see the baby for 2 hours in my office with you, you there. Oh, so Justin was supervising also? Justin and Justin's attorney were there while Kelsey was visiting with Caden? He shouldn't have been there. You're right, he shouldn't have been there. Even though that part of the restraining order has been vacated by Judge Karp. I keep wanting to say Judge Krupp, but it's Judge Karp, different county. That is crappy. He shouldn't have been there. Thank you for this. We covered this the other day, Big Old Dog, about the 2 children that were found dead in Wesley. She was arrested the other day. We covered it already. And she apparently agreed to be extradited from Vermont, which is where she is right now. Moving on. How come we are assuming all these things about Justin? Like what? Like I'm assuming that that's what his attorney told him, because that's good advice for his attorney to give him. That's good advice. We read all the papers. His papers were kind of gross, and she's gonna smack back. She's gonna clap back at everything he alleged in his moving papers. And if you didn't watch that show, it's pinned in the chat. It's also in the show notes below the video. Moving on. It should be noted, too, that father has not allowed mother's family to see the child either, other than mother's sister attending the child's baptism. This child is being ripped from an entire side of his family, and it certainly does not serve his best interests to do so. Mother seeks to simply share time and decision-making with the father, but father's vitriolic and self-serving opposition should be a red flag to this court. Father has pointed to no single piece of evidence where a mother has ever harmed their son, attempted to harm him, or where he has ever been injured when in her care. None. Father's behavior is aimed to punish, not protect. Roman 2, relevant law. Although there may be some conflict between the parties, joint legal and physical custody may still be appropriate if the conflict concerns the parent's own relationship rather than being about specific areas of disagreement regarding the children's care, custody, and upbringing. Citing some cases, it is always, 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 in every court that I'm aware of, what is in the best interest of the child. That is paramount in any family court case. What is in the best interest of the child? 2, true joint custody is divisible into 2 components: shared legal custody and shared physical custody. Shared legal custody carries mutual responsibility and involvement by both parents in major decisions regarding the child's welfare, including matters of education, medical care, and emotional, moral, and religious development. The best interest analysis is a child-centered one that focuses on the specific needs and interests of a child and how these might best be met. In custody matters, the touchstone inquiry is what is best for the child, and the determination of which parent will promote a child's best interests rests within the discretion of the judge, whose findings must stand unless they are plainly wrong. Judge has a lot of discretion. The judge shall consider whether or not the child's present or past living conditions adversely affect his physical, mental, moral, or emotional health. The issuance of an order under 209A shall not, and in of itself, constitute a pattern or serious incent of abuse, nor shall an order entered ex parte under said chapter 209A be admissible to show whether a pattern of serious incident of abuse has in fact occurred. Okay, so this leads me to believe that this should say incident. Okay, the 209A order was the DV restraining order, and so it is not to be used, according to this case, in and of itself as evidence, or this ex parte, they're saying this ex parte 209A order shouldn't even be admissible to show whether a pattern of serious incident of abuse has in fact occurred. Shouldn't even be admissible in this family court proceeding. This is what he's hanging a lot of his hat on. Ex parte application that he filled out. Roman 3, argument. Willingness to cooperate and co-parent. While father cites in his motion the case of Macri v. Macri and Mason v. Coleman, which provide that for joint custody or shared responsibility to work, both parents must be able to want to cooperate in making decisions for their children, and that the parents must have a willingness to work together. Father has not shown his willingness to do so. In fact, the evening after the 209A restrictions about the parties' communication and contact with the child were vacated, mother immediately opened an Our Family Wizard account, messaged father on April 14th and again on the 26th, sending him the link to connect on Our Family Wizard twice, and offered to pay for his Our Family Wizard account. Footnote 4, let me see if they explain what it is here. Footnote 4 says both parties had suggested Our Family Wizard was the best form of communication moving forward. See parties' filings. Our Family Wizard is an app that a lot of family courts use in a lot of different states, and it is in a lot of contentious cases the only way that the mother and father are allowed to communicate. They're not supposed to be texting each other, not supposed to be emailing each other. The only communication they're supposed to have is between this app called Our Family Wizard. Father not only failed to open his Our Family Wizard account, even as of this filing, but had blocked mother from communicating with him via text message, which was only learned on April 21st. I don't know if I just glossed right over this, but Kelsey even offered to pay for his Our Family Wizard account. I don't know how much it costs, but apparently he blocked her text messages, and she only found out about it about a week ago. Despite mother first suggesting Our Family Wizard, then father also suggesting it in his instant motion filed on April 3rd, father still will not create the account to communicate about their child. Begs the question, what was the point of vacating those provisions from the 209A if father is simply going to ignore mother and block her in every way from communicating? What is clear is that father is the one who's unable to cooperate in making decisions for their son or have any willingness to do so, contrary to the Macri and Coleman holdings. Mother should not be the parent who is excluded from decision-making or parenting time because father cannot co-parent or even open the lines of communication. On April 18th, 2026, counsel for mother emailed counsel for father detailing this issue. and expressed how concerning it is that father will not even open an account despite seeking it in his own motion filed with the court. Mother, through counsel, even agreed that no Our Family Wizard messages would appear on social media per father's request in his motion, but there was still no movement by the father. That doesn't look good in front of the court. It doesn't look good when through attorneys you're trying to cooperate and the other side won't cooperate. It doesn't look good. Also, understand that lawyers bill by the 10th of the hour, okay? They bill every 6 minutes. So if they got to make a phone call, if they got to draft an email, every 6 minutes, there's a bill. And for example, and this is probably a cheap example, if your attorney bills $600 an hour, do the math. 1/10 of an hour, $60 every 6 minutes. Father himself argues in his motion that the parties must work together to ensure that all decisions are made after a meeting of the minds between both parents. See page 8 of his motion. Father has made working together or having a meeting of the minds impossible by blocking mother and refusing to open the account. B, well-being of the child. Father argues that he has been the primary caregiver for 9 months and should therefore remain in that role. What father fails to recognize is that he surreptitiously set up that scenario by obtaining a 209A based on false allegations. Here we go. Buckle up, buttercups. The false nature of those allegations are addressed herein more fully. Should have waited until the trial was over to address this. Can you blame her? Everything he said, she's going to now contest. In addition, father fails to recognize that mother, due to the mistakes of the North Andover police and the postpartum mental health of mother at the time her life was collapsing in an instant, mother was accused of assault with a dangerous weapon, which resulted in her being in the hospital through August, then held in custody awaiting trial initially until late December, then released from custody in December to reside with her parents in Methuen for house arrest. Is it Methuen or Methuen? Methuen? For house arrest through the criminal trial when she was found not guilty in March of 2026. Right. And she wasn't given a copy of the affidavit. You are correct, Jimmy D. She was not given a copy of the. She didn't even know what the allegations against her were at that point. And then they tell her, oh, Justin's coming over or something, like he's coming to get the baby. Maybe she didn't even know that he was coming to get the baby, but he did show up to get the baby, and they thought that that was a cool thing to do. I think she testified she did not know that he was coming. She did not know that he was in the house. Methuen. All right, thank you. I did not have time to pull up that Jimmy Fallon. Is it Jimmy Fallon who does that video with Ben Affleck and Matt Damon and pronounces every Massachusetts town? Methuen. All right, thank you. When mother was released from custody, father refused to allow mother to see their son in any capacity other than through 2 emails per month, which shares limited information and photos of their son through counsel. Yeah, that's what they agreed to when she was in jail, that he would have to send updates twice a month. Mother would have had no ability to fight for any parenting time given her then pending criminal trial. The issue is that mother had a Fifth Amendment right against self-incrimination, which would have had to be waived in order for her to defend herself and argue the salient points of father's myriad allegations against her. Essentially, mother was faced with a catch-22 and a no-win situation to fight these simultaneously pending court battles. Mother had to rely on father's goodwill, good faith, and good character to even see her son on any level, even Zoom, FaceTime, or a supervised visit. We all know what father chose: to say no to mother at every turn. So the fact that father relies on 9 months of caregiving without mother's participation is a product of his doing and his choices to keep mother apart from her growing baby. Father can claim it was an abundance of caution. It was in an abundance of caution to protect the child. But the fact we all know very well in family court is that there are numerous ways to keep a child safe, which is while also opening up the mother-child connection. Father simply took advantage of mother's catch-22 position, unable to defend herself from drowning under the 209A, which resulted in an inability to seek parenting time with her own son. While mother's mental health was surely a concern, there were ways to work through that collaboratively, but father refused. It is not disputed that based on the limited knowledge of mother has of Caden sent through attorney emails with updates and photos, Caden is healthy and meeting developmental milestones. Mother is not alleging anything contrary to that. Mother is simply seeking to see her son and be involved in his decision making, which is the presumption of this court, absent other factors. It is astounding, though, that father can even suggest that their son is thriving when he is and has been without his mother. Such a statement in his motion reflects a true absence of understanding of early childhood, the best interests of the child, and any respect for the role of a mother in a child's life. I do think that it is very well written and is telling a story in a very cohesive way that people can understand, even if they don't know anything about this case. And Julie Hess is his attorney, is Kelsey's attorney in this phase of the litigation. It is preposterous to believe that the party's son is thriving without his mother. Father's recitation of what he does with and for their son is basic parenting. While he can be credited with doing exactly what he should be doing as a father when it comes to basic support of a child, it does not mean that the other parent should be excluded from the same ability to parent the child. In January 2026, mother asked to send a care package to father for their son. He refused to allow her to do so, citing the 209A. The fact that father's behavior has been only to keep mother sidelined speaks volumes and is unwarranted. Provider involvement and professionals to assist father in parenting. Including the pediatrician's commentary out of context from records that father refuses to share with mother due to him having sole legal custody under the current orders is simply hearsay and should not be considered by this court. If you're not sure what they're talking about, they're going to tell us. Father alleges that the pediatrician commented that their son is doing well, quote, particularly to him living with the father and father's family in Stowe. A pediatrician would not make such comments out of context. We all agreed. So many pediatricians and nurses in the chat. In what other environment would the child be living in comparison? What question was posed to the pediatrician for such commentary to be made? Did the pediatrician comment that the prior home was insufficient? There are more questions created than are answered by this commentary in his motion. Without the full clinical note or understanding of the context, this comment makes little sense and yields nothing in terms of whether mother should be awarded parenting time or shared legal custody. The fact that father refers to an early intervention specialist having worked with their son since July of 2025 is shocking. Listen to this. This was never disclosed to mother in any of the bi-monthly updates. The only mention of it was as follows. On 10/29/25, quote, Caden's surgery was scheduled and completed in September. They fixed a hernia on the right side. Doctor stated everything went well, and there's a very small likelihood it will cause any problems in the future. He's up to date on all scheduled vaccines. Early intervention was recommended due to the trauma he sustained, which is a state-run program, and they come biweekly to ensure Caden is meeting his developmental goals. End quote. Kelsey had no idea that Justin had been going to an early intervention specialist, because remember, he quoted the early intervention specialist in his papers. And some of you in the chat, more than one of you, are early intervention specialists, and you said that you never, ever, ever would have said or put in your notes the things that Justin quoted in his papers. And they're going to probably tell us what they are. So let's keep reading. Not only is this report inconsistent with what father has just reported in his motion, but father never again updated mother about these visits. Father also did not say he had already begun that specialist involvement by October when he reported it had only been recommended. But his motion indicates that it had been started months earlier, as early as July of 2025. That's not good. It's not good when you're only communicating twice a month because that's your agreement and you failed to put that in there. But you're telling the court it started in July. Father also failed to provide the March 31, 26 update to mother and did not share the letter, but offers it here to this court. It is questionable why father could not share that with mother via counsel per the October court order, and it is questionable why it was written other than clearly sought for the purposes of litigation. Father continues citing commentary by this quote specialist, but mother has access to no records, has been shared no records, nor has she ever before father's instant motion been shared the name of this person. The commentary appears to be generalized updates that the child is doing well, which is wonderful, but it begs the question as why these records have not been shared with the mother and what quote progress is being considered. It is laudable that father has done well with the child, but this specialist has only had contact with the father, and it is questionable if this specialist is even authorized to comment on a child's well-being when the mother is excluded from his life. Clearly, father feels he must buttress his fatherhood with approval from others, but it still has nothing to do with whether mother should be allowed parenting time and shared decision-making of her only child. Again, mother seeking involvement with her child is not saying father is a danger to the child. Let's go to the chat for a minute. A desire for civil discourse. Thanks for your tense. Says premeditation keeps Kelsey away from her baby as long as humanly possible. Then let her see him once. What do you mean, Judge? She just visited him Saturday. Thank you for your 10 and your thoughts. Bruce Wayne says, because of the abuse done to Kelsey and Karen, every woman I know says, if in a jury trial, will not trust any cops that testify. Trust has been eroded. Thank you, Bruce Wayne. Not all cops are bad. Not all cops are bad. I don't know if you live in Massachusetts, but maybe that's becoming the general feeling there. Bridget says, purple hearts for Kelsey. Thanks, Bridget. Fia 5. And David says, in the Army as a leader, I was taught to train my replacement. Thank you very much. Fia 5. Thanks, David. Apparently, this specialist also made recommendations for even more additional specialists for the father, as he could not care for the child properly, as he needed further help and support from 2 additional professionals just to feed the child. What? While it is applauded that father sought support when he felt he needed it, this is precisely why mother should be brought into the picture. Mother had no problems learning her son's cries or voices, which Ms. Romeo wrote was part of her job for father. Feeding him and caring for him when she was present during the first 4 months after birth. While things change over time and the child's needs change, father should be including mother in seeking assistance with the help with the care of their child, not excluding her and seeking outside sources when it is clear that he needed help. Well, we didn't see the report because I think the report was sealed. And so we didn't see it. But apparently, there's Ms. Romeo wrote in her report that part of her job was helping father feed the child. And that it says here that he needed further help and support from 2 additional professionals just to feed the child. Just to feed the child. Interesting. Moreover, father never informed mother of these additional professional recommendations, nor did he inform mother. He actually hired 2 additional professionals. The lack of information about these important professionals in the child's life is a violation of the October court order. Hernia surgery is the next category. This allegation is, again, a serious misrepresentation. The child was scheduled for surgery for July 2nd, 2025, but the parties needed to fast the child before surgery, which became intolerable for him, and the parties struggled with how to do that. Mother asked father to ride with her to the hospital for the surgery and to help her in the car ride with a very upset, hungry, and herniated child. He refused. Given the difficulties, she asked to reschedule very quickly. However, after the 209A order was served on June. Okay, so the surgery was scheduled for July 2nd. She's saying the baby had a fast before the surgery. As everyone knows, you have to fast before surgery, usually from at least midnight the night before, sometimes earlier, depending on the procedure and the anesthesia required. And she asked Justin to help, and he said no. However, after the 209A was served on June 30th, 2025, father failed to take the child to this initial appointment and also failed to obtain a new appointment until 2 months later. And mother could do nothing to ensure that it happened, as she could not only communicate with the father or the child's providers, as she did not have legal custody, but she was also in the hospital fighting for her life. Fighting for her life. Thank you. Stina says, I love Ms. Hess calling out everything, point by point by point by point. Every single point that he makes, it's point, counterpoint, point, counterpoint. And we saw that in their text messages. That's right, Emily. See? That's right. Thank you, Scott Messerschmidt, for reminding everyone to please hit the like button to push the video out. Moving on. She was in the hospital fighting for her life for 53 days, 5 surgeries while she was in there after being shot in the chest. By a fellow officer. Something happened right now on StreamYard. So all of the super chats just disappeared that I had not pulled up yet. And so I apologize, because you know how much I love to thank you, but the ones that were in the super chat column have just disappeared. Thanks, StreamYard. So I am not ignoring them. I just can no longer see them. I've been buffering for you. Have I been buffering? Mods, if I'm buffering for you, maybe just refresh your browser. Everything was blurry, but now it's not. Well, I'm on Ethernet, so it has nothing to do with my connection. Maybe there was a glitch. Maybe StreamYard glitched. Not surprising. C, mother's ability. Thank you, Scott. Thank you, Scott. Thank you, Scott. You're the greatest. Okay. All right. Scott is able to screenshot the super chats for me. All right. I got a desire for civil discourse on your 10. Thank you, Bruce Wayne. Overruled, sit down. Martina, I got that. Yeah, I think there were 4 more after that, Scott, but they just disappeared, so I don't know. David Reese, maybe I got through them. Maybe I did. Maybe David Reese was the last one that showed up. Okay, moving on. Mother's ability to care for the child and mother's mental health. This is important. The most important, in my opinion. Although father alleges, page 11 of his motion, that mother failed to respond to certain discovery requests, he fails to mention 2 very important details that negate this intentionally misleading representation. First, mother objected on the basis that her criminal trial was pending, and she was not going to affect her defense, providing mental health records at that time, but would supplement the same. Second, on March 30th of 2026, mother, through counsel, in an effort to make that supplementation, provided a drafted confidentiality agreement to the father, seeking for this CA to be signed, confidentiality agreement to be signed And then she would provide the mental health information that has been sought. Mother did not need to do this. In fact, she could have sought for this court to perform an in-camera review of the records before being willing to disclose her health records at all. But Mother, in good faith, was trying to decrease litigation for these parties and get to the heart of the matter quickly, right? Why are we going to give all our money to the lawyers when we could just agree on things? In camera review is when the judge takes something and looks at it privately and decides whether or not to give it to the other side. To date, Father has still not returned an edited draft of the confidentiality agreement, nor a signed version. Mother has no obligation to provide Father with mental health records absent some confidentiality agreement. In-camera review by this court or other protections provided to her by law. Mother is more than willing to provide evidence of her mental health, but not without protections, especially given how this case has been subjected to social media and other media that would risk opening these records to the public. Mother is, I would not show her mental health records, just to be clear. Mother is not alleging that Father would personally do that, but protections should be put in place, which Mother has initiated and to which Father is not responding. For Father to now use his non-responsiveness against her is simply not acceptable. Further, for Father to opine on her mental health diagnosis is far from good faith, but done to cast a negative light on Mother when she suffered from postpartum depression, a common situation in new mothers, and something no court should hold against a mother in a custody battle when those struggles are behind her. The statistics on postpartum depression in new mothers in the US is between 10 and 20% and is not a new phenomenon. It must be addressed, not punished. Mother has addressed and overcome it. Mother had a therapist, Emma Manderville, through Massachusetts General Hospital, having heightened anxiety and depression from the pregnancy. Mother had seen this therapist since October of 2024. By March of 2025, Mother knew she was, quote, not herself and was crying often. Remember, the baby was born February 2025. So she was seeing the therapist during her pregnancy, before Caden's birth, and then after his birth. She voluntarily went to Lawrence General Hospital to be assessed in March of 2025, 1 month postpartum, and she was diagnosed there with postpartum depression. Mother was released approximately 12 hours there and followed up with her regular therapist. So she voluntarily went there. She was not sectioned. Section 12 in Massachusetts is an involuntary hold. Usually it's for 72 hours. In New York, we call it a 72-hour hold. And I think he tried to make that argument that she was that she was sectioned. But let's see if they bring it up. Notably, Mother underwent a fitness for duty evaluation on May 21 of 2025. This evaluation was performed by Dr. Jill Durand, a licensed psychologist who was asked to perform this evaluation by the North Andover PD after Mother was diagnosed with postpartum at Lawrence General Hospital and placed on a short leave. Okay, so it seems that she probably went on leave from March through May when she underwent her evaluation. The report was not generated until June 11th, 2025, just over 2 weeks before being served with the 209A. Dr. Durand cleared Mother for returning to work, including use of a firearm without restrictions. So Dr. Durand found her fit to return to duty as a police officer. Hold, please. Dr. Durand found that Mother was fit to return to duty with no restrictions, and she reported that Mother had no disciplinary issues or complaints filed against her and no issues of attendance on the job. Dr. Durand recommended that Mother continue in therapy, which Mother has done consistently. Mother then started to see Dr. Paul Zeisel, a psychologist, in the summer of 2025, who performed an evaluation and prepared a report on July 3rd of 2025 relative to mother's mental health. He found, we've seen Dr. Zeisel, first of all, testify as an expert witness before. Correct me if I'm wrong, but I believe it was in the Lucy Medina trial. Was it in the Lucy Medina trial? He may have also testified in another trial, and he's an excellent expert. He's so good. It was Lucy Medina. Thank you. He was so good. And we've seen him come to court hearings before in support of Kelsey, and he has been very, very supportive. It was Turk. Thank you. Thanks a lot, girls. It was also Turk. That's what I thought. Okay. Mother then started. I'm sorry, no sound. Can you hear me? Check 1 2. Check 1 2. Can you hear me? I don't know why you have no sound, Nurse Jones. He's also going to be testifying for Lindsay Clancy. That is correct as well. Here we go. Mother then, wait. He found, Dr. Zeisel found that mother's actions on June 30th, after she was served with the restraining order, was to a reasonable degree of psychological certainty, not a calculated act of malice, but a desperate, reflexive cry for help brought on by an overwhelming wave of hopelessness. He reports that on June 30th, she was met with an unimaginable confluence of stressors, experienced an acute, transient, psychological crisis. Dr. Zeisel further reports that her actions that day are clinically consistent with a severe state of acute emotional dysregulation. Thank you. Dr. Zeisel reports that mother's behavior was compelled by a state of profound grief and abandonment rather by a reasoned intent to harm herself. That's not a complete sentence. Hold on. Dr. Zeisel reports that mother's behavior was compelled by a state of profound grief and abandonment rather than by a reasoned intent to harm herself. Okay. He's saying that she did not intend to actually take her own life, that she was feeling this profound grief and abandonment, not that she really wanted to take her life. He found that at the time he performed his evaluation in the summer of 2025, she posed no credible risk of harm to herself, and that no clinical evidence suggests that she poses a physical or mental danger to the party's son. He assessed that, to a reasonable degree of psychological certainty, the risk of harm from reunification is all but non-existent. He went on to assess that the continued separation of mother from her son is clinically detrimental and harmful to mother and child, and that the prolonged separation can disrupt and impede the child's developmental growth and capacity. Mother saw Dr. Zeisel virtually while in custody in 2025, then started to see him weekly from January 2026 to March 2026 after her release. Commencing earlier this month, mother has started to see him twice per month. Okay, so she has decreased her visits from every week to every other week. I'm sure it is very expensive for her to see Dr. Zeisel. Mother has been seeing Dr. Khan since January 2026 for medication regulation. She takes fluoxetine and lorazepam. Reminds me of White Lotus. I need a lorazepam. I need a lorazepam. Okay, what is this? Allie in Texas, you put that in the chat no less than half a dozen times. She'll go over it when she can. Thank you. I don't even know what it is. So now I'll stop and go back and see what it is if it's been put in here 6 times. Oh, please. I don't know. I'll have to look for it. If it's in my inbox, I'll go over it. Let's just get through the 25 pages of this one first. Lorazepam. I need a lorazepam. Friend of Dog gifted 10 memberships. You're amazing. Thank you so much. That is really sweet and generous of you. I do not pick who gets the gifted memberships. YouTube does select randomly. And so, welcome to the 10 new members. And also, Lula Bell has been here for 5 months and says so. She had antenatal depression also. It seems that way. Seems that she also had depression during her pregnancy. Yeah, that's what the experts are saying. Thank you, friend of Dog, once again. Mother recently met with a trauma specialist, Dr. Knopf, for intake. Her next full session is May 14th, 2026, who she will see every 2 weeks. Her current diagnosis is anxiety and depression, which is successfully regulated with medication, yoga, Pilates, exercise, and the support and guidance from her providers as detailed here. Mother has gone through a traumatic experience after suffering postpartum depression, and she is no longer diagnosed with postpartum. Mother has survived this ordeal from her own core strength and deep love for her son, which Dr. Zeisel recognized in Mother. Letter from Mother to Father. Mother wrote the letter, Father cites, in May of 2025 and left it on the counter for him to read after he finished work. She was present. He read it, hugged her, and cried. The fact that Father alleges he just received it after the conclusion of the criminal trial is a complete falsehood. Father uses Mother's genuine affection and effort to be a better partner in the face of her postpartum against her. It is nothing more than heartless and disrespectful. Allegation of harm by Mother to Father and others. Father's motion is inaccurate and misleading as to the North Carolina incidents. In total, Mother pled once to simple assault, not against any boyfriends, as Father alleges, and after 100 hours of community service, it was expunged from her record for this very reason. So these minor incidents could not be used against her in the future to tarnish her name and reputation to move past mistakes when she was 21 years old. Yet, Father is still doing this very thing over and over to Mother. Despite this incident from her past, Father still moved into her home, still had a baby with Mother, and still asked her to marry him. Father knew that Mother was no threat to himself or their child, yet he raises this expunged past incident 8 years later. It has no bearing on today's issues. Mother never attempted to take her own life in high school. These allegations come as an effort to smear Mother, not to protect their child. The deposition of Michelle Mitchell is very telling, but not in the way Father seeks to present. In the same deposition, which Father fails to point out, is that Ms. Mitchell admitted she had tackled Mother on the steps of the home, bear hugged her, and threw her into a wall. Well, you know what I say, there's always 3 sides to every story, right? Your side, my side, and the truth. Michelle, they called her Michelle in some of the papers. She also testified at the criminal trial, remember? She's a corrections officer. She testified against Kelsey. She was a bridesmaid. Tell us more. Michelle also admits standing over Mother when Mother sat on the steps, which Mother asserts was an intimidating stance after just having slammed her into a wall when Mother tried to leave the property after everyone had been drinking and she wanted to leave. I'm assuming this is the part of the Jack and Jill bachelorette party. Mother did not punch anyone in the face, nor were there bruises or police reports that Miss Mitchell had. In fact, Ms. Mitchell admitted that everyone had been drinking at that party where Ms. Mitchell said this incident occurred, even herself. She also admitted that she did not know the reason mother wanted to leave, to which she admitted in her deposition. It is mother's position, essentially, that she had asked father to stop drinking and using drugs at the party, and when he refused, they argued. Mother then wanted to leave and started down the steps to just go home when Ms. Mitchell intervened to stop her for unknown reasons. Well, I guess they really are telling us everything. Michelle gave a deposition, and she said at this deposition that she, Michelle, had tackled Kelsey on the steps of the home, bear hugged her, and threw her into a wall. And she admitted standing over her in an intimidating stance. After just having slammed her into the wall, Kelsey wanted to leave because she got into an argument with Justin because she wanted him to stop drinking and using drugs at the party. And when he said no, they argued. Then Kelsey wanted to leave and started down the steps to just go home when Ms. Mitchell intervened, bear hugged her, and threw her into the wall. Well, that's a totally different story than the one Justin wanted us to believe. Thanks, Pauline, for gifting 5 memberships. You're a sweet pea. Thank you so much. Thank you, Laura, for our 21 months together and for your compliments. Love you so much. Love you so much. That's a far different story than the one we were told about Justin being in fear for his life and having to leave and go to a hotel and Kelsey stealing his stuff and throwing a Stanley Cup at someone's head. And if you don't remember, go back to the show that's linked in the show notes. But you're telling me Justin responded, so we'll have to look at that next. It's going to be longer than I thought. Mother did not assault any former boyfriends, and mother has a good ongoing acquaintance with Mr. Minotti. In fact, father contacted Mr. Minotti on more than one occasion, and Mr. Minotti asked father to stop harassing him and that he and Kelsey had a fine ongoing acquaintance and to stop searching for negative things about her. He would testify to the same if called to trial. Oh, yeah. He tried to bash her other relationships with her prior boyfriends. And apparently, Minotti says he will testify on her behalf. So there's that. September 2024, a mother asserts that she has never attended anything called a welcome party, but there was an event they attended together. Father got extremely drunk. Clearly, evidenced by father admitting that mother drove them home while pregnant. Most men would have driven their pregnant girlfriend, engaged later that month, to and from the event unless he had been drinking, which is what happened here. Oh my gosh, didn't I say that exact same thing? She's pregnant. Why is he making her drive? This is the one where they went to I don't remember which party this was. He had so many stories about things that happened. Mother asserts that father was disrespectfully engaging with a woman at the event, and mother was upset. Oh, that's a nice way to put it, Julie Hess. Father was disrespectfully engaging with a woman at the event, and mother was upset. Father blamed his behavior on his intoxication and asked for mother's forgiveness. Remember, they were not yet engaged. They became engaged later that month. Was he hanging all over some other chick? Was he flirting with some other chick? Was he making out with some other chick? I don't know. But his excuse was, I was hammered. Please forgive me. Oh, look, here's an engagement ring. Father blamed his behavior on his intoxication and asked for mother's forgiveness. She did not drive over 110 miles an hour. In fact, mother does not even have a speeding ticket on her record. Oh, remember that? He said she got really angry and she started driving the car up to 110 miles an hour. Mother did not tell father to find another place to live, though she could have, since it was her home where they resided and were not even engaged at that point. However, father did ask for mother to marry him later that same month, clearly evidencing that mother did not act in the erratic and dangerous way he has described for the court. His credibility in the reporting of this incident is zero. Preach, sis. October 2024. These are all the incidents that Justin brought up in his initial motion, and she's countering them incident by incident. October 2024. Father's sister Ashley had texted father upset that mother was coming on the trip because she said it was a family-only trip. Oh, is this the trip to Croatia? Oh, yeah. Tell us everything, Kels. Tell us everything. Father confided to mother that they are engaged, having a baby, and that he did not understand why his sister was acting so hateful. The parties did, in fact, go on this trip to Croatia, but mother admits that she overestimated what her body could handle while pregnant, as the trip consisted of hiking, long walks, long nights, and early mornings. And she already knew Justin's sister Ashley was mad that she was going because it's supposed to be family only. Meanwhile, he's engaged to Kelsey and she's pregnant with their baby. And it's also a long flight to Croatia. Mother was at the point of her pregnancy where her lower back caused a lot of pain. Later to find out the baby was pushing on her sciatic nerve in her lower back. I mean, listen, we've all been there, right? We've all been there. Not only the hormones, the inability to get comfortable, the sciatic pain, difficulty sleeping, all of it. Father's family vocalized to each other that she was being dramatic about the pain because 20 weeks isn't even that pregnant. Okay, ladies, go to town on that comment. 20 weeks isn't even that pregnant. 20 weeks is the halfway point. The halfway point. They say pregnancy is 9 months, but it's really 10 months because it's 40 weeks. Hello? Wow. This caused her to no longer vocalize the pain she was in during the trip, but then quiet presence caused by his family but then quiet presence caused his family to accuse her of being miserable and ungrateful. Man, I don't know. I mean, I could see this. They probably paid for the trip, so now they're calling her ungrateful. She's trying to shut up about being in pain, so they're calling her miserable. She's ruining our trip. We didn't want her to come anyway. And all they want to do is drink, and she can't drink because she's pregnant, and she can't walk long distances or hike, and she's exhausted. Yes, exactly. Thank you. CW 1971. Were they telling her to smile? Oh, why don't you smile more? You'd be so pretty if you would just smile. This is a good point too. Mother Oat says, though, if the baby cries out in pain, are they going to call the baby ungrateful and miserable? Well, apparently he doesn't even know how to feed the baby because he had to get two experts or two specialists to teach him how to feed the baby and what the baby's cries meant. Is the baby wet? Is the baby tired? Is the baby hungry? Is the baby in pain? Deborah says, OMG, tell me the sister hasn't been pregnant without saying she hasn't been pregnant. Yeah, calm down, Kelsey. Calm down. Why don't you calm down? You need to calm down. You need to calm down. Why don't you calm down? Why are you so cranky? Why do you always have a puss on? This is very nice information, Creamy Null, but you should know, just for your information, that putting the N-word in the chat, not the one that Proctor uses, about kill an N-word in Canton Day. But the other N-word that refers to, the guy from Germany, that's not a word that YouTube likes to see. So I deleted it. Thanks for your history lesson and thoughts. During a particular 6-mile hike, something mother would normally enjoy when not pregnant, she fell behind from the rest of the family. When she fell behind, father's brother, Brendan, would yell from ahead, "Hurry the F up." Oh, that's nice. Wasn't Brendan one of the guys who went into or broke into Kelsey's house because he needed a whole bunch of guys to go in there and get all of his stuff? Hurry the F up, Kelsey. Oh, Kels, why'd you even go on that 6-mile hike, girl? You should have just taken a bath or went to the spa. Spend some of your own hard-earned money, get a massage. This happened on multiple excursions when mother would fall behind and father would just shrug it off. Or sometimes he would tell mother she needed to hurry up so his family didn't get mad. Wow. I mean, I would say that she dodged a bullet by not marrying this guy. But the fact of the matter is she didn't dodge an actual bullet because of this guy, in my opinion. Isn't it ironic? Don't you think? A little too ironic. And yeah, I really do think that she did. In fact, she's very, very lucky in some ways that she did not marry this man, although she will have to co-parent with him and his family, apparently, for the next 17 years at least. During this trip, the family had planned an off-roading excursion. The parties determined that it was too dangerous for a mother being pregnant, so the parties stayed behind and rented bikes instead. His siblings were angry and felt that mother was holding their brother back from their family vacation and made that very known to mother, telling her she was a burden and should not have come on the trip. Laura says, "This is making me so mad. I am reliving my first marriage and the torture I went through." I'm so sorry. But we're now learning everything about Croatia because he's been screaming about this Croatia trip for a long time. And the entire family has held this against her. And he used this in his petition for custody for his 209A order, saying that he was afraid of her because of things that she did on the Croatia trip. I see my eyes twitching now again. It's making me twitch. I feel you. Some people are very lucky to have amazing in-laws. Some people not so much. During this 13-day trip, these situations made mother feel like she was on eggshells, a burden for being pregnant. And there were multiple times where she would cry and tell father how they made her feel. But it was not that mother wished she was not pregnant, nor did she say that she wanted to end the pregnancy. They were making her feel like a piece of garbage. And she's saying, "I did cry." But Justin said in his papers, oh yeah, she said she wished she never got pregnant and that she wanted to end the pregnancy and she was going to do something to end the pregnancy, and she punched herself in the stomach and she did all of these things that made me fear for the baby's life and my own. The Goodmans say, "We both have the best in-laws." Shout out to the Goodmans and their parents. Law mom, Kelsey, you are not a burden. And what's so crazy is that Kelsey fell in love with a guy whose parents are so different from her own because her mother and stepfather and father have been with her at every court hearing all through the trial when they could be in there because of the sequestration order, and have been with her every step of the way. And it seems to me that his parents, based on the way she's describing this, did not like her at all. It's like they told Kelsey, "How dare you?" Says Zeta Zay. Right, Winnie the Pooh, reminding us that he ran away from danger instead of running to danger. Yes, thank you, Winnie the Pooh. Later that trip, mother was experiencing spotting from pregnancy. That's never a good thing. Due to the stress of that trip, and mother talked to father about the bleeding in the airport. She expressed how upset she would be if she had a miscarriage due to making the decision to go on that trip. Father immediately got upset with mother, questioning if she was blaming his family. He was immediately defensive and has now taken this narrative and twisted it for his gain in this case. Wow. 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 I don't know if I even need to explain that any further to you. She was spotting in the airport. She was very upset. She thought maybe the stress of this trip and how mean these people were to her, she would be so upset if she did miscarry because of what was happening on this trip. And he twisted it around and said she wished that she never got pregnant and didn't want the baby. Oh my God. There's always another side. And here it is. Thankfully, all was okay with the baby. Her bleeding had nothing to do with mother ever punching herself or harming her child, but rather a product of the stressful trip and father's family being insensitive and hateful. Wow. He said she was punching herself in the stomach. Upon returning from their trip that evening, mother made tea for the parties from a gift she had bought father, and which had arrived early when they arrived home. They relaxed with their dog on the couch that night for a short period. Mother was shocked to read father's allegations in his papers. Didn't he say she was throwing stuff all over, throwing things from the counter, etc.? Mother was still very upset, though, and felt confused and distressed at how she was feeling during her pregnancy. She informed father that she wanted to find treatment, and she later found that at Lawrence General Hospital. She talked with her OBGYN and her therapist at that time, and they discussed medication for her. But given pregnancy, they had to be careful with what medication they prescribed. Father did not beg to go to any facility, nor did he ask her to go to inpatient treatment. That's what he said in his papers. He was begging her. That was not necessary, as mother was properly taking care of her own mental health at that time. It seems to me that, in my opinion, Kelsey was taking care of everything. And the one time that she wanted to be taken care of, that she wanted a pass, to maybe relax and rest and for somebody to take care of her, was during her pregnancy. And they couldn't even do that. They made her feel like a burden. November 2024. Mother asserts that this simply did not occur as described. This is now the second time that father accuses mother of going 110 miles an hour, this time between North Andover and Boston, a heavy traffic and police surveillance area. Again, his credibility is zero with this narrative. December 2024. Oh, we've got one good guy in here. All the guys in here are good. Masters of Criminology says, isn't that what us guys are supposed to do? Yeah. It's your baby. Thank you for understanding. December 2024. Father did, in fact, attend a wedding at this time, and the parties did agree that she should not attend given her pregnancy and attempt to protect mother and child, not harm herself, as father's narratives consistently relay. During his trip, mother was in the hospital for severe abdominal pain during her pregnancy. When mother tried to reach the father in Mexico, she could not reach him on his cell phone. She then tried the front desk of the hotel. The front desk reported that he was at a club and was not answering the phone in his room. Father admitted to going to the club and blocking mother's phone number, which is why she could not reach him via cell. Really? Your wife, who's like, I don't know, in her third trimester or close to her third trimester, is trying to reach you, and you block her number because you're partying in Mexico? Oh, dude. Oh, dude. And she's in the hospital for severe abdominal pain? Wow. She also told us that he just blocked her recently And she couldn't text him to set up his Our Family Wizard account. Father never offered to take the next available flight home. Father did not stay on the phone with mother during the 40-minute drive home from Boston. March of 2025. Mother did have a breakdown on March 9th of 2025, and she immediately sought help. Remember, this was a couple weeks after baby Caden was born. Maybe Caden was 3 weeks old at the time. That is the same day she was diagnosed with postpartum depression, diagnosed in Lawrence General Hospital. Mother agrees that she was on the kitchen floor crying. She went to the hospital voluntarily that night. There was no prolonged argument. Mother asserts that she never refused to let father leave. In fact, he never tried to leave. Father called her stepfather and mother for assistance. Mother never attempted to grab the baby and not let go. Mother's parents are available to testify to those events. Mother was discharged about 12 hours after admission and was advised to follow up with her therapist and OBGYN, which she did. Mother was very open and honest about the postpartum depression with father, which he is now using against her in this case. Mother was placed on leave around this time, but later had an evaluation for her fitness for duty performed by the doctor, Jill Durant of PCS for the NAPD. This evaluation was reported on June 11th, 2025. Mother was cleared for return to work without restrictions. Her return date was scheduled for less than 1 month later, July of 2025. May 2025. The parties were having dinner with friends, and mother did get upset that evening. David, father's friend, was not simply reminiscing, but talking about father and his ex-girlfriend and things of a sexual nature. Mother informed them that such conversation was inappropriate. Not only did it make her feel understandably uncomfortable, but their child was next to them. Father later apologized, but none of the erratic behavior he describes occurred. Yes, remember he said that they went to introduce the baby to their friends at a brewery, because that's a great idea, and that his friend David just innocently brought up his ex-girlfriend, and Kelsey went berserk. With respect to their son rolling off the bed, mother admits this occurred, but to convey this to the court as though mother cannot care for the child is disturbing. Mother had already woken up at about 6:30 a.m. that morning to feed their son, and father was at work. Clearly, he knew she could care for their son and left mother and son at home together without pause. Mother and child's routine at that point was to wake up early, feed him, and then allow him to go back to sleep in the party's bed until approximately 10 a.m., with mother laying by him. Mother would place pillows all around the baby. However, their son had somehow rolled over all the pillows at 3 months old, and he fell off the bed onto a pillow. Mother called father immediately, and they kept a close eye on him for a good 24 hours to make sure all was okay with him. They were under the impression he never hit his head or any part of his body because he fell off the bed onto a pillow. As such, the parties did not seek medical treatment. Him, their son, showed no signs of injury or pain. Babies roll off the bed. Prince loves the lead. It happens, says Queen BKC. Many parents co-sleep with their children for years. Co-sleeping is a thing, too. I guess, yeah, everyone's a horrible mother if you ever let your baby roll off the bed. First of all, it's May of 2023, May of 2025. Baby's 3 months old. That's kind of early to roll over, right? I mean, I don't remember. My kids are so old now, but God says babies roll off beds, adults roll off beds. It happens. It happens. They fall skateboarding. They fall down the stairs. They fall. Doesn't mean she's a bad mother. June 2025. Father did, in fact, attend a mercy meal for one of his coworkers. He was supposed to arrive home at 7 p.m., but he did not arrive until 9 p.m., completely intoxicated. Mother was visibly upset about it and tried to express her concern about his drinking. She was also worried about him driving while having been drinking. Well, can you understand that? It doesn't say hammered, it just says completely intoxicated. I submit to you, could be one and the same. Nevertheless, she had ordered dinner for him for a 7 p.m. arrival, and he did not arrive home until 9 p.m. Mother was upset, and she left the house for about 15 minutes and went for a drive to have some distance from the situation. Had father been so concerned of mother acting erratically and afraid for the baby's safety and mother's safety, he would have called the police to check on mother and child driving away, but he did not do so. With respect to the Jack and Jill party that the parties attended, mother has videos of that evening where she had been drinking, but not acting negatively or erratically. Uh-oh, there's video from the bachelor and bachelorette party. Ms. Mitchell testified that everyone there was drinking, not simply mother. In fact, it was mother who asked father to stop drinking and smoking weed and to come to bed, which is why she asked him to come upstairs to the bedroom. However, father refused and continued partying. Ms. Mitchell did not know who pulled anyone's hair. On pages 46 through 49 of her deposition at Exhibit C of father's papers, Ms. Mitchell admits that the way she was bear hugging mother on the steps when mother was one step below her, that she did not know how, if at all, mother could reach around behind her to someone standing on the steps above or below them and reach their hair. I don't remember any hair pulling allegations, but that could be just me. Ms. Mitchell had no idea who pulled someone's hair and did not actually witness it. Yet father alleges that mother pulled someone's hair, completely taken out of context and untrue. Ms. Mitchell also admitted that mother kicked her in the knee only after Ms. Mitchell had already assaulted her on the steps. Mother's reaction was in self-defense to keep Ms. Mitchell away from her. Cat fight. Yes, do not fear. Dahlia Lynn says, I hope she has really good security at her new place. Guess who's a security expert? Kelsey FITZSIMMONS' dad. So yes, don't fear. It is all good, I imagine. Lilibel, thanks for your super chat. Says, Justin's relationship with his mom and sister is weird AF. The sister's giving jealousy vibes like he is her fiance. Rat House, hi. How does Justin change his... Well, that's great. Thank you very much for your funny chat. Indy Cindy says, Team Kelsey, thanks for being here for a year. Appreciate you. Mother then walked out of the home. This was, remember, this was an Airbnb in Maine. It was Maine, right? Maine. Not Vermont, Maine. Mother then walked out of the home. The home was surrounded by woods with a hiking path. The woods were only about 10 feet from the door where mother exited. These facts were admitted by Ms. Mitchell on the record. Yet father tries to paint the picture of mother acting crazy and walking into the woods. In fact, mother wanted to remove herself from the situation and walk down a hiking path. While father cites Ms. Mitchell's testimony as saying her reaction was just not normal, Ms. Mitchell later admitted that because she did not know what occurred between the parties, nor heard what was said, that she can't define what's normal, not normal. I wonder if all these people are going to come in to testify, if this is going to be an evidentiary hearing tomorrow. It'll be interesting. The most concerning part of father's allegations is the way he twisted mother's messages to him. For instance, he alleges that mother said she was going far, far away. But father's own testimony at mother's recent trial in March revealed that she said to a land far, far away. And he knew that meant her father's property in New Hampshire, which father knew very well. In fact, he proposed to mother there. He also knew mother's father called that place a land far, far away. Oh, okay. Okay, Justin. And her father had a little song when mother was little that they would sing about the property to get the kids excited to go. Father twisted that phrase when trying to spin the narrative against mother. In fact, father knew mother was not a danger to the child. Their text messages reveal it all as follows. When I told you that this was 24 pages, I didn't realize that it's all single spaced. So it's really like 48 pages of reading for me. So you can have to give me a minute for me to get a drink. Hold on. Dobie Mama, thank you for buying me 5 matcha lattes. I really, 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 really need it. Says, thanks for all your hard work and always keeping it classy. It's not easy. Really, it's not easy. Thank you, Shelly, for buying me 5 matcha lattes. You guys are amazing. Thank you, Shelly. And another. So that's 6 from Shelly. Thank you, Shelly. You're the greatest. Moving on. Okay. Here we go. Oh, honey, Gigi's here. Oh, honey, she is that Gigi. She's here and she gifted another 5. You're the greatest, Gigi. Thank you so much. Yeah, Dad also has a new response. It's in my inbox. It's another 20 pages. So we'll see how my voice goes finishing this one. Thank you, Gigi, for gifting 5 memberships. You're amazing. You making a diaper cake? Oh, that's a fun gift for a baby shower. That's okay. I will excuse your tardiness. That is an excellent excuse. You can make the diaper cake while you listen. Hope you're feeling better. Here we go. Oop. Come back. All right. Here's the text messages in which Kelsey say will prove that Justin knew she was not a danger to the child. June 29th, 2025. Remember, June 30th was the shooting. June 30th was the shooting. So this is the day before the shooting, the day before he went to court to get the order. June 29th, 2025. Father explains he will go to mother's home where they had resided together until father chose to end their relationship, unbeknownst to mother until that day. He said he needed to retrieve some belongings. In the myriad of messages between them that day, mother not only asked father to come home and to work on whatever it was that was straining their relationship, but she also messaged the father asking if he will be with their son on June 30th so she can do CPR training at work. Father texts the following: I will not be guilted or manipulated into this, meaning coming to the house. And these are more texts from Justin. Caden should absolutely be okay. There should be nothing wrong with him. Is there? I will pick him up if you need or want me to, happily. Otherwise, I'm not coming over today. What he needs is safety and calmness. That is all he needs right now. I'm not coming over today. Give me space and stop, please. When she asks him again to come see her and the baby and get his truck, his response is, no, I will get it at some point tomorrow. I need space. Let me be, please. He didn't even have his truck. Remember then the next day he didn't have money for gas, but he needs space. Okay. Later that same night, after 8 p.m., he does in fact go to the home and retrieve belongings. He did not take the child, nor did he have police do any wellness check. Mother and child were fine. Mother, sensing something was odd, told him she was calling her mother to come to the home, and when she arrived, they could come in together. That was a good idea. Father reports that he had asked mother to call her mother, but that was mother's idea. At no time was father truly concerned about their son. He refused several times to pick up the baby unless mother needed him to do so or wanted him to do so, which he clearly wrote in a text. If he was concerned, he would have gone there and taken the child at her request to come home. Remember, she said something like to him, because we read the text messages once, it's not babysitting, Justin, if it's your own child. It was like he called it babysitting. I'm twitching again. Can you see it? This is like stressful for me. June 30th, 2025. Father still did not pick up the child or go to the residence. Mother had to take the child to her CPR training for work. Meanwhile, and to which Ms. Mitchell testified, father was up the street at his buddy's house with other individuals plotting how to get a restraining order against mother. Ms. Mitchell couches it like they're concerned for mother, then the child, but when questioned on it, they never even inquired. They never even inquired where the child was. And she could not or would not tell counsel what plan they actually had. Notably, the child was at CPR training with mother, safe and sound at North Andover PD training. Here's the relevant excerpt starting at page 83, line 6. Okay. Question. So how did the group of you on the 30th decide to meet up to discuss Kelsey? Answer. Now remember, this is Michelle talking. Katrina called me and we just made a plan to go to his house. Question. You and Katrina? Answer. Sorry. Yes, we made a plan to meet at Hunter's house. Question. What was the plan? If I am indeed glitching, my mods will tell me. And so I haven't heard from any of them. And so please refresh your own device. Thank you. I'll close some of these windows just in case it's getting drafty here. Could be, but I don't know. Hunter's house. Question. What was the plan? Answer. To keep Kelsey safe. Question. What was the plan? That's an objective. What was the plan? Answer. We were trying to meet up with her to get her some mental health help. This is Michelle's deposition. Question. By doing what? Answer. To get her help. Question. By doing what? Answer. We don't know. Question. You didn't ever come up with a plan. You just sat around and talked about it? Answer. We talked about how to keep her and the baby safe. We had thought she was suicidal and let me just X that out. And our plan was to meet up with her and go from there. To meet up with her where? Answer. Wherever she would meet us, she wouldn't meet with us. Question. Who tried to meet up with her? Answer. I did. Question. Okay. By doing what? Answer. I asked her to meet me to go get coffee and she declined. Question. That was the 30th, right? Answer. Yes. Question. And didn't you learn that she was supposed to be doing some kind of training? It was either the 29th or 30th at work. Answer. The 30th. I was in touch with the Lieutenant Whitaker from North Andover, and that's when he told me that she was there doing in-service CPR training. Oh, Michelle. who's a corrections officer, still, I think, right? Reaching out to North Andover PD, to Kelsey's, going behind Kelsey's back to call her lieutenant to talk about her, to find out where she was. Huh. Interesting. Question. So even though she was at work with colleagues doing training to save lives, you still thought she was suicidal? Answer. Yes. Question. Okay. And how long was she in the CPR class or training? Answer. I don't know. Question. So you don't know the hours she was there? Answer. No. Question. Okay. So what was the plan that you guys came up with at Hunter's house to help her? Answer. We were trying just to get her. There was no exact plan set in stone. Question. Okay. So what were the ideas that were thrown around? Answer. I don't know. I don't recall. Question. What do you mean you don't know? You were there, right? Answer. Yes. Question. Okay. So what were the ideas that were thrown around to get her some help? Answer. I don't recall ideas being thrown around, but she just needed some mental health help. Interesting. Aren't you the one that like put her in a bear hug and threw her against the wall? Question. Were you all drinking that day? Answer. We were not drinking that day. At least I was not. Question. Was anybody else? Answer. I can't speak for anybody else. Question. Well, you witnessed them there at Hunter's house, right? Answer. I can't tell you if they were drinking at all that day. Question. In Hunter's house, did you see anyone drinking that day? Answer. No. Question. You sure about that? Answer. Yes. Question. And I'm sorry, you might have said this earlier. Was Justin there too? Answer. He was. Question. Okay. At Hunter's house? Answer. Yes. With Courtney. Courtney was the sister who came into the house the day of the shooting, not the same exact day, when they were not drinking at Hunter's, and took the baby. Question. And that's up the street from where the North Andover home of Kelsey was, correct? Answer. Correct. Question. How far up the street? Answer. I'm not sure. Within a 5-minute drive. Question. Drive, not a walk? Answer. Correct. Yep. Question. Okay. Answer. 5-minute drive. Question. And I'm not familiar with the area. Is it on the same street? Answer. I don't recall. I know it's close by. Question. Okay. You don't remember any of the ideas that people threw around to try and help this woman? Answer. I know Justin was trying to make sure the baby was safe. And then he ended up going to the courthouse to file for a temporary restraining order and temporary custody. Okay. But you said in the beginning, well, this is my words now. You said in the beginning you wanted to figure out how to get her mental health help, but you can't remember one idea that anybody thought about, except for you do know that you wanted to make sure the baby was safe, and that he ended up going to the courthouse to file for temporary restraining order and custody. Do me a favor, remind me if Michelle was the maid of honor or a bridesmaid. I don't remember. Remember they met at work, and I think that means they met at work when Kelsey also was a corrections officer at one point. Maybe that's where they met. I do not know. Be in trouble. Says they were all helping Justin set her up. Just a bridesmaid. Oh, just a bridesmaid. Thank you. Thank you, Suze. Thank you, Ryla. Okay. Well, if she's at training, where's the baby? Answer. I do not recall. I don't know. Question. Mom's in CPR training. Justin's at Hunter's, and no one knows where this kid is? Answer. You'd have to ask them. It's not my baby. Oh my God. Can you just imagine? Can you just imagine from the way she was on the stand, the tone in which she probably testified at the deposition? Question. You guys were meeting to figure out how to keep Kelsey and baby safe, right? Answer. Correct. Question. Nobody thought to think, where's the child right now? Great point. Great question. Answer, somebody was probably watching the baby. Question, nobody found out? Answer, I don't know. I don't recall where the baby was. Question, how long were you at Hunter's house? Answer, several hours. Question, okay, between what times? Do you recall? Answer, 2 p.m. up until maybe 5:30. Wasn't this a Monday? June 30th, 2025? Now I have to check. This is how I fall into rabbit holes. Because if the 28th was the night of the fight and it was a Saturday night, I'm thinking June 30th, 2025 was a Monday. Does anybody have a job? All these people are at Hunter's house from 2 until 5 or 5:30. Does anybody have a job? Just a thought. Justin was a firefighter. I understand that they work, 24s, and then they might have a couple days off. Maybe corrections officers do the same. I don't know about Courtney and all of the other friends that were allegedly trying to help Kelsey's mental health and make sure the baby was safe. Question, and one of the ideas that was thrown around was to get a 209A, correct? Answer, I don't recall. Question, one of the ideas that was, wait. Oh, she asked again. One of the ideas that was thrown around was to get a restraining order against Kelsey, correct? Answer, correct. And one of the ideas was to use that restraining order to take away the child, correct? Correct. And were any of the ideas to call her doctor? Answer, I don't have her doctor's number. Question, Justin had been with Kelsey for how long before this meeting on the 30th? How many years? Answer, I don't know, within a year or 2 years. Question, okay, so did you ask Justin if he knew who her doctor was? Answer, no. Question, nobody threw out the idea, let's talk to one of her doctors and talk about if they can call her and check on her mental health? Answer, no. Back to the papers. Then, between those 2 days of June 29th and 30th, father and his sister had called the police asking how to keep mother from going to New Hampshire, which again proves he knew mother was going to the New Hampshire property, not some crazy land far, far away. He knew where mother meant that she would be going with their son, a family vacation property in New Hampshire. He even admitted on the recorded line that mother is, quote, telling me she's planning on taking the baby up to New Hampshire. How do we know this? Because we've listened to the recordings. All the recordings. And we've read the transcripts of the phone calls that Courtney and Justin made to North Andover PD. The police on a recorded line let him know that he really had no rights, especially to take the child from the mother and prevent her from going across state lines. The lieutenant said, quote, they don't have the right to deny her child, end quote. Father asked, do I have any rights? It's my turn to have the kid for the night. The lieutenant said, no, through the police department, we don't have that ability. Father and his sister asked what they could do to prevent her from going to New Hampshire. At no time, while speaking to a lieutenant, did father say he was afraid for mother or child or father's well-being. The sister then piped in and said, quote, we need to get the baby out of her hands, and asked if it makes a difference that she was trying to take the baby out of state. The lieutenant responded, quote, it really doesn't. It's her child. Sister said, if we file this, it will end horribly. Would a police officer come with us to get the baby if custody were ordered? To get the baby. And then in parentheses says, if custody were ordered after filing a restraining order. The lieutenant then explained that if that was filed and he was granted custody, then they would take the child. Charles Argo, thanks for tuning in from South Africa, says, Justin is lucky Kelsey's stepfather is such a gentle giant. I think his family are evil. His mother, mainly sister, are behind this plan. There's a weird bond between Justin. I'm 67 with 2 daughters with babies. Thank you very much, Charles, for your super chat from South Africa, it's a good time to point out that the opinions of my viewers are not necessarily my opinions. And just because I highlight a question and or super chat does not mean that I necessarily agree with what they say or don't disagree with what they say. Robin, thank you so much for being here for 2 years. Yay. Did you get your new colored cupcake? Congratulations, Robin G. Rat House, thanks for your 5. Sorry, Miss Melanie, for the language, but Justin's lack of human instincts is frustrating. That's okay. I just don't like talking about, menstrual products. It's just not my thing. But don't worry. Thank you. I wasn't going to read it out loud. Strong Leg, thanks, says, please use my language. I'm of the opinion the family is a big old bag. Oh, Richard, sorry, I'm not mad. I appreciate that. But, you too do not want to be sued for defamation. So, thanks for your 5. Guide your actions accordingly. Proverbial rug. So it's not just in it for the money runs from its responsibilities too. Oh, right. Not just the sounds of the firearm. It's responsibilities too. Thanks for tuning in from across the pond, Strong Leg. So, yes, thank you so very much for another 5. Appreciate you. Megan Johnson, remember when he said none of her friends will ever want to talk to her again when she was clinging to life in the hospital? We remember, Michelle. Thank you. Thank you, Megan Johnson, for your 10. Wake up, America, and resist 2413. He wants space. Maybe Elon Musk can drop him off up there. That was funny and not defamatory. I appreciate it. Yellow Ledbetter, hello. In my opinion, they met at Hunter's house because they knew Kelsey would have to drive by and it would set her off. The cops serving her and make her go nuts. Gaslighter he was, never worried about Kaden. Could be. Who knows? Here we go. Moving on. Father then filed for a 209A late on June 30th of 2025, which was issued based on his affidavit. His affidavit, however, was replete with hearsay and witness statements that have, in this opposition alone, been clearly refuted after questioning under oath. Further, he used that far, far away language against her, even though he knew and admitted to the police in the June 30th audio that she was just taking the child to New Hampshire, a family vacation property. He twisted it to sound crazy and scary. He failed to report to the court that the mother had invited him back home on June 29th and 30th, asked him to be with the child immediately the prior 2 days, and he refused to go there or take the child, actually arriving the night of June 29th, taking belongings and leaving the child. Remember, he also took his firearms, only his own firearms. Left her with hers because he was so worried about the baby's safety. He told the police in the June 30th audio that he just wanted his night with the child. Not that he felt that the child was unsafe in any way. He could have taken the child when mother asked him to help when she had CPR training, but he did not choose to do that. Rather, he chose a restraining order with complete misrepresentations and half-truths. Father argues in his motion that mother frantically kept driving by Hunter's house. However, if he felt she was doing that with the baby, would a father not try to stop her and or call the police to get the baby? The fact is that father knew she was not doing that. In fact, he knew mother had CPR training that day. And also, he had told mother he would meet her at the park that day, which he never did. Mother had to drive past Hunter's home to get to and from these areas. Mother did not notice father's truck at Hunter's and mother did notice father's truck at Hunter's and wondered why it was there when he told her he had no gas money to get there to take their son when she had CPR training. Father admits in his motion that it was only after he had been hanging out with his friends for hours that he decided to apply for a restraining order. This was not a decision based on fear, but rather a narrative created just to allow father the rights he was upset he did not have when it came to decision-making for the child, which he had just discovered that day on the phone with the North Andover PD. Allegations of fits of rage. Mother denies these allegations outright. They're also not credible. Father has no phones, police reports. I'm sorry, not phones. Father has no photos, police reports, or other evidence that these incidents ever occurred. Even so, they are between 1 to 2 years ago and do not evidence the current situation. Some alleged incidents were when the parties had a child together, and yet he still chose to co-parent with her and ask for her hand in marriage. Father's narratives are not credible. His narratives over and over involve times when they are in a car together, yet he continued to ride with her, ask her to drive him when he was intoxicated and she was pregnant, and also drive her places. He never stopped being in a car with her, despite her behavior, as he describes it, to be scary and appalling. Right? Remember, he said she went over 100 miles an hour. On the other hand, mother has videos of father intoxicated, falling over in the house, and unable to function. Mother has videos from their security cameras in the home where he is smoking marijuana constantly. He even has been put on administrative leave from the fire department for his failure to abstain from drugs and alcohol. Mother was never in such a position with her work, who actually cleared her to return to work after a postpartum episode. Yet, father fails to account for his own drug habits and alcohol consumption, trying to ruin mother's reputation and ability to see her only child with his allegations. Mother has already submitted to a 12-panel hair follicle test, which came back clean. Okay, there it is. He says his came back clean also. It is available to the court at this hearing. Summary. Father alleges that he believes it is important for mother to be reunited with their son. However, despite the 209A provisions being vacated on April 14th, all but the no abuse provision against the father, footnote 5, which says notably not involving the child in any way, father refused to allow mother to see their baby from April 14th to April 24th, even supervised. Father offered mother a visit between mother and child on April 25th at his attorney's office, supervised by counsel. While mother was ecstatic, it was completely dictated by father, and he knew mother had to agree or not see her child at all. She jumped at the chance. That visit went very well. And that, you remember, we opened the stream with that post by the Justice for Kelsey FITZSIMMONS account that said they had a visit on Saturday and it went great. First visit in something like 298 days apart. Father is also seeking for mother to only have 42 total hours, which is less than 2 full days with the child over a period of 2 months. Nothing in his allegations, considering the lack of credibility in the same, warrants such limitations, nor does it provide a way for mother to be truly reunited with her child. The proposal that mother has made actually does that. Footnote 6. Oh, please, that's a long footnote. Footnote 6. Mother's proposal, taking into account any doubt this court may have about mother's safety with the child. Let me see if I can make this bigger for you. Hold on. Not really. Mother's proposal, taking into account any doubts, it was probably better this way. This court may have about mother's safety with the child on any level, allows for mother weekly supervised visits on Sundays for 5 hours with a supervisor to occur at mother's current residence 3 times. Um, that any? I don't know. Not really. The supervisor would provide a summary of the parenting time, how the child presented with mother, and raise any concerns via a written report provided to counsel of the parties. Mother's proposal, given time is of the essence as the baby is growing each day and mother is losing quality time to watch him grow, then expands to the supervisors being the maternal grandmother and or stepfather and occur at mother's residence for 3 days per week and 5 hours each day for 2 months. So they're proposing a step up visitation from the supervisor that they would have to pay, a court appointed supervisor, to Kelsey's mother and father, or mother and stepfather. The maternal grandparents who the Superior Court had previously vetted for mother's release from custody would report to all counsel of the parties with a summary of the parenting time, how the child presented with mother, and raise any concerns. Therefore, the parties would follow a traditional 223 shared parenting schedule, with mother having Mondays and Tuesdays, fathers having Wednesdays and Thursdays, and the parties sharing in the weekends, Friday to Sunday, alternately. That is what is called a 223 parenting schedule. It is shared 2 days with mom, 2 days with dad, every other weekend. See mother's proposed order. This proposal gives gradually increasing time with the baby, despite mother not believing it's necessary at this juncture, as her mental health is good, she's in therapy, and by all reports, she is doing well. Mother recognizes, however, that the standard for this court to make a decision is the best interests of the child. And given all the allegations, this court must consider all factors to make a well-rounded decision on a temporary basis. Mother believes that her proposal takes into account all of the issues presented to this court. Further, the fact that father seeks for this supervised and limited time to be done at the same center where he has been using the so-called specialist for assistance in parenting his own child means this particular center has heard all of father's narratives and allegations and has likely completely biased this center against mother, even if unintentionally. That's a really good point. This would be the same center who has already allegedly written that father is the child's favorite person. Remember, he put that in his papers. To presume that this particular center would be neutral in any type of supervision is beyond comprehension. There is no need for a 60-day supervision of nothing more than 42 hours in total, where nothing positive or natural can happen between mother and child. Mother's proposal, on the other hand, allows for a stepped-up parenting reunification in a natural environment, supervised initially and gradually stepped into a more normalized plan. Father can point to no evidence that suggests the type of supervision he is seeking is best for their son, or that it is warranted at all. I think I'm getting cross-eyed reading the single-spaced, tiny, fonted document. All right. Because mother suffered from postpartum depression a year ago does not mean she should be ostracized in this fashion from her only child, especially when she's willing to provide her mental health records to this court and to father with the appropriate protections. What father is seeking is punishment, not co-parenting. While father is seeking a guardian ad litem too, it is known that a guardian ad litem will not complete any assessment in less than 2 months. And even then, a hearing would need to be had to implement any recommendations, which father could easily delay by simply saying he needs time to cross-examine the guardian ad litem in a deposition or at an evidentiary hearing, which would further delay mother's access to the child in any substantial way. Effectively, seeking a guardian ad litem is only putting distance and more delay in the mother-child reunification. Reminds me of a song, Mother and Child Reunion. Okay, I digress. While mother admits she has had postpartum depression diagnosed in March of 2025, and some behavior at times was due to that mental health issue at that time, father's narratives are not credible, and he seeks to capitalize on mother's short period of postpartum to create some ongoing mental health problem where mother is a danger to their child. However, father's own behavior disrupts those narratives when he's had opportunities to retrieve the child from mother. He chose not to do so, avidly refusing to go to the home and pick up the child because he needed space. Unless she really wanted him to do so, per his message to her on June 29th of 2025, when he retrieved belongings from the home, but not the child, when he left the baby with mother when she was home for maternity leave, and he was gone all day. The child was always safe, and he knew that. His alleged fear of her and for their child is not credible. Mother is not a danger. She has had the mental health support from therapists and psychologists. She had the fitness for duty evaluation performed in June of 2025, which cleared her for work without restrictions. She passed a full panel hair follicle test in April of 2026. She remains in ongoing therapy and was acquitted of the charge brought against her. Wherefore, mother respectfully requests that this court deny father's verified motion, dated today, April 27th, 2026. XOXO. Julie Hess, attorney for the custody portion of Kelsey FITZSIMMONS' case. Kelsey signed it also, meaning she read it, and everything in it is true. And this was served on Justin's counsel today, and apparently they've already replied in a 20-page response because they worked all day on it at however many hundreds of dollars an hour they charge. But this right here, this paragraph, if you're just tuning in now, is a great summary of the argument. Mother is not a danger. She has had the mental health support from therapists and psychologists. She had fitness for duty. She was returned to work. She was cleared June 2025. She passed a full panel hair follicle test in April, this month. She remains in ongoing therapy, and she was acquitted for the charge brought against her. Also, Dr. Zeisel, they didn't say it here, but Dr. Zeisel has in his report opined, and he is a very famous expert witness, that what she experienced on June 30th of 2025, when she saw her life crumbling before her very eyes, was a transient condition, and it has passed. And we heard a response to every single one of Justin's allegations in his original motion. Strongleg says, remember King Solomon and the two mothers in First Kings? Yeah, I'm getting chills. Thank you very much for your time. Appreciate you so much. All right, thoughts, questions, comments, concerns. Hang on one second. Before we think about reading Justin's response. Or skim through it for the pertinent portions if you want to do that, because it's 20 pages and my voice is straining. But I'm here for you, so we'll do it if you want to. I think we could skim through it because I have tomorrow's show scheduled for 9:45. Hearing is at 10. There will be cameras, so we're going to be able to look at it. Hang on. Okay. I don't think she's not going to get full legal and physical custody. I don't think that's going to happen. I think they should get 50-50 shared custody is what I think should happen. I think a baby needs both parents, and I think it's kind of unrealistic to think that either one of them is going to get full custody. and the other one's not going to have any contact. Yeah, if we read it in the morning before court, though, that's going to require me to come on early, and I don't think I want to do that. I think we can look at it now, but let me just pull it up for you because we can skim through it. A lot of it is procedural. And we know a lot of the procedure because most of you have been here from the very beginning of this case. And I'm not sure what's going to happen tomorrow, but I do know it's a different judge. One second. It's supposed to be Judge Ulwick, but it's not. It's somebody new. Yes, Poe Hunters. The 223 request for custody seems very equal and seems normal, and that is. And so there is that. Robin, thank you for your Venmo. Says, thanks for continuing to keep us updated. Go Abs. Yes. You like my hat? You like my hat, girl? Thank you. That was a nice sweep, right, Robin? Put some brooms in the chat, would you? Oh, Scott, I did tell you I'd be done by 7, so you could watch the Pens and the Pens and the Flyers. All right, well, let's look at it quickly. Let me see. Where did I put it now? I just got to see where I put it. Thanks, Emily, for sending it to me in a easily downloadable format. For some reason, when I got this one from the court, I have a Mac and it wouldn't open for me in my Mac. I've tried it a bunch of different ways. It wouldn't open. But here's the father's opposition to what we just read from Kelsey. And boy, were they working all day, working overtime. He must have a lot of money to fight this. Let's see where we are. Get the highlighter ready, etc. Why is Justin allowed to live outside the mileage boundaries? I don't know anything about the mileage boundaries. I can't answer that for you. Mileage boundaries for what? For his job? For co-parenting? I don't even know what that means. I have no idea. If they have, like, if you're talking about to be a North Andover firefighter because he lives with his parents now in Stowe, maybe that's what you're talking about. For some reason, I had the thought that you were talking about his co-parenting, but I don't know. But he is living with his parents. All right, let me close some of this stuff. I also had Michael Easter's report to go over with you, but this came first. This came first because it's tomorrow, and we can go over that another day. Another day. All right, here we go. This format might be better because let me be able to make it bigger. Let's see if we can do that. Boy, Justin didn't waste any time in responding to this. I don't know what time it was filed, but at some point while we were on the air, that's when it was filed. All right. Here we go. This is Justin's clapback. Father's verified opposition to mother's motion for further temporary orders. Here comes Justin. He wants to tell us everything, and he's going to take 20 more pages to do it. The father requests that this honorable court deny mother's motion for further temporary orders. Oh, he's going to double down now. Here he goes. He loves to double down. Him and his attorneys both. They love to double and triple down, even when they've been called out and their version of events has been disputed by even Michelle's own testimony. And let's see what it is, possibly, that he could say is a good reason to deny the motion. Here we go. Here's his brief background and procedural history, which we do not need to read. I will scroll through it. So in case you would like to read it, you can read it. But we've all been here for all of it. Okay. They agreed to stipulate to modify the restraining order. And there's the body of that. There's a hearing scheduled on that at July 16th, 2026, 10 a.m. There's like two different proceedings going on now. There's the restraining order proceeding, which is in Lawrence. And then there's this custody proceeding, which I guess is also in Lawrence, but a different judge in a different part. Okay, April 14th, they filed a joint motion to move the hearing date from April 23rd to April 28th, which is tomorrow. Blah, 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 blah. And they're going to be here tomorrow, April 28th, 10 a.m. Before they were supposed to be heard before Judge Elwick, and then it says, according to the online docket, it appears that Judge Mitchell Munivar will be hearing these motions, which it is. And then there's a pretrial conference before Judge Elwick on July 15th. And here's his argument. I want to get to like him disputing any of these facts here. Here's their highlighted portion. They think their argument is that the court should consider evidence of past or present abuse towards a parent or child as a factor contrary to the best interest of the child. Remember, he's saying Kelsey did not only abuse or threaten harm against the child. She didn't harm the child, but did harm him because he says that she punched him at least at the Jack and Jill party, maybe another time. And where there is a finding of a pattern or serious incident of abuse, the judge must employ a rebuttable presumption that sole or shared custody with the abusive parent is not in the child's best interest. And this makes sense now. Doesn't it make sense why they kept the baby away from Kelsey for so long? Quote, and this is according to a case from 2010. They quoted the case for this purpose. Quote, while there's no definitive checklist of factors to determine the best interest of the child, we consider certain constants such as, this is in bold, which parent has been the primary caretaker of and formed the strongest bonds with the child. The need for stability and continuity in the child's life, the decision-making capabilities of each parent to address the child's needs, and the living arrangements and lifestyles of each parent, and how such circumstances may affect the child. Okay, that's their checklist. There's no checklist really, but this is what they think the court should consider. And I think he's going to go on to say that because the child has been with Justin ever since Kelsey got shot on June 30th. Of course, he should stay with Justin. I'm going to scroll through this a little bit more. And paragraph 7. This is all in bold. Father's primary concern is the 14-month-old child's emotional and physical safety and well-being. Due to his age, the child is unable to speak for himself and unable to report his own observations during visitation. It should be noted that each and every court order in this case, as well as in the 209A case, has been the product of an agreement of the parties in counsel, right? Because Kelsey was in jail and she couldn't see her baby in jail. Father supports mother's relationship with the child so long as it is safe and healthy. Father has little to no information regarding the status of mother's present mental health or treatment. Well, she just told you everything in her sworn to affidavit. Father's counsel does have a report dated July 31st, 2025 from Dr. Paul Zeisel, who was mother's expert witness for the criminal matter. Mother spent approximately 2.5 hours with the child and father on Saturday, April 25th, 2026, just 2 days ago, in the presence of counsel at a visit suggested and facilitated by father so that mother did not need to wait to see the child. Oh, should we give him a slow clap, everyone? Thank you so much, Justin, for allowing Kelsey to see her baby for what you say was 2.5 hours, but what other people say was 2 hours. Father's sole motivation is to ensure the emotional health and physical health and safety of the child and to protect the child from public attention. Pursuant to several court orders, the father has had legal physical custody of the child since June 30th, nearly 10 months. The child was 4 months old at the time. The child is healthy, thriving, well cared for, and is meeting all of his developmental milestones. Again, he says that he has kept her apprised as to his development, etc. June 30th, he was granted custody because of the restraining order that he got ex parte. Parties agreed on in October to a stipulation. Okay, here's what he says. Since obtaining legal and physical custody of the child nearly 10 months ago, this is paragraph 19, the father has been the child's primary caregiver. Father is responsible for Caden's day-to-day care, including but not limited to feeding him, clothing him, bathing him, putting him to bed, playing with him, reading to him, scheduling and transporting him to his medical and surgical appointments, scheduling his early intervention visits, etc. Remember, Kelsey said that she didn't even know that he was undergoing early intervention and that he needed to hire 2 other experts to teach him how to feed the baby. Yeah, you're right. We need the button. Yeah, get his work schedule right. He hasn't been working for a while, but I don't know. I tend to think maybe his mother and his sister are helping him. I don't know. As is detailed in the plaintiff's verified motion, according to the child's pediatrician and early intervention specialist, the child's thriving, making great progress, growing. Yeah, we heard all this in your first one. What's different? What's different here? Oh, he's saying here the child's early intervention development specialist recommended that he also consult with a social worker on a regular basis relative to parenting and support, as well as a child nutritionist to help support the child in learning how to self-feed. That's right. At 14 months, apparently, not to baby shame, but apparently Caden doesn't know how to feed himself Cheerios. Anybody have a 14 months old? Tell me like where your kid is or your grandkid is with regard to feeding itself, his or herself Cheerios. I don't know. Says he went to all of her OBGYN appointments. He's attended the vast majority of the pediatric appointments. Prior to the party's separation, he says when the father was not working to financially support the family, the father was at home taking care of the child. Team Brittany's babies were making Cheerios from scratch by 14 months old. Miku's here. She's got a 12-month-old. She says she's been feeding herself food since she was 6 months old. Well done, Mama. Julie had custody of her grandson for over a year and he was feeding himself at 9 months. Good job, Grandma. Emma says, my twins at 5 months old were feeding themselves with toast, scrambled eggs, etc. Hold on, hold on. Comments are just coming in too fast. Okay. Let's see, where was footnote 3? Oh, when they said that the child, the specialists say that the child is making great thriving, making great progress, growing, is very well cared for, is healthy and happy, is meeting all developmental milestones, and has a close attachment with the father. Footnote 3 says, according to the child's early intervention development specialist, notes that dad continues to be the minor child's favorite person. Oh, he's going to put this in there again? It's gratuitous. Kelsey doesn't have a report. There's no report that says that. They haven't been provided with any notes or any report that says that. This child is securely attached to the father, and the child's cautious around new people and unfamiliar situations, preferring to be held only by the father when he feels unsure. It's because he hasn't seen his mother for 298 days, maybe. And what early intervention specialist would put that in notes? I don't know. You guys are, one of you at least, or 2 of you are early intervention specialists. Would you ever put that in your notes when you knew there was a custody battle looming? After the child was born, the father took 3 weeks off from work to be home with the child. Yeah, because the mother was fighting for her life in a hospital bed after being shot by her coworker. because of your ex parte bump of a restraining order. Mother's assertion that she was the child's primary caregiver during this time is simply not true. Oh no, 3 weeks off after the baby was born. Okay, so that would have been in February. Sorry, I got to take that back. I'm taking it back. This is in February. The parties were both actively involved in caring for the child. In fact, the father was responsible for the lion's share of caregiving, as the mother would often tell the father to care for the child because she would become overwhelmed and claim that she couldn't handle it. Oh my God, here we go again. You want to throw more dirt? You want to throw more dirt? Thank you so much, Justin, for taking 3 weeks off of work after the birth of your only first child. After you and your family treated her like a piece of garbage during your Croatia trip, and maybe she's a little bit tired. Yes, thank you. Stinky Face says this is all scripted parental alienation. He says he wants Kelsey to bond with Caden and then says why it shouldn't happen, often based on false accusation. Thank you. That is why the thumbnail here is entitled Parental Alienation. Get the play on words there? Got it? Got it? Common Sense Investigator says, except that we have 200 some videos of him outside smoking God knows what. Right, and hiding like a teenager, smoking it out the window and lighting a bowl. Emily C. says, insecure attachment manifests as intense clinging to a caregiver due to inconsistent, unresponsive, or unpredictable care. And Three-Eyed Catfish says, delayed feeding may come from overbearing caregivers who are unwilling to clean a mess from the learning process. Control issues, early signs of caregiver control, no parenting necessary. And Law Junkie is an early intervention specialist and says, never, ever would we be allowed to state that in a report. It's not factual. It is subjective. Thank you. Then he goes on to talk about what the mother says. And then he says, and then he's doubling down again. Perplexingly, mother fails to acknowledge that on March 9th, 2025, less than 1 month after the child's birth and during that period of time, the mother was involuntarily held at Lawrence General Hospital pursuant to a Section 12 after exhibiting violent, aggressive, and erratic behavior in the presence of the then 3-week-old child, which prompted mother's stepfather to call 911. She's saying that didn't happen. As a result of this situation, the mother was placed on administrative leave from her job at North Andover PD, as such, to state that she was on, quote, maternity leave from and after the child's birth, and through such time, the father sought and obtained the 209A abuse prevention order simply not true. I hate this. I hate this so much. I hate reading this. I hate reading all of this. I just want you to know, I hate reading all of this. I do. I hate it. I hate it. It's just like, the fact that all this is public and it's easy to get and you can pull it right off the court website. You don't even need to be an attorney. It's just it's like we're peeping toms looking in on someone's life that we should not be privy to. And the fact that he just continues to sling mud at the mother of his child in some sort of game, like it's all about winning. It's all about winning. Who's going to win? Who's going to win? I need to win. It's more about being right and winning than it is about doing what's in the best interest of the child. Right? Because again, he's got to throw out another 20 pages of gaslighting. I don't like it. Call me crazy. And then he's going to get into what the attending physician at Lawrence General Hospital and the town of North Andover's community support coordinator, Crystal Clooney, what she determined, that due to mother's erratic and violent behavior, mother should not be discharged and that she was not in any position to care for a baby at that time. Who is this Crystal Clooney? How did he get her medical records outside of an authorization to get them? According to the attending physician, mother had experienced an episode of psychosis at home. I thought he didn't have any medical records. Who the hell is Crystal Clooney? Did she breach HIPAA? Is she a friend of the family? Even more perplexing is that mother refers to an assessment by Jill Durand, cleared her to return to work. And then he admits here in footnote 4, despite several requests for the same through both formal and informal discovery, father's counsel has yet to receive a copy of this evaluation. Right. Because like you're doing here with Crystal Clooney, you're putting all of her private medical information out there. Oh, thank you. Crystal is a licensed social worker who works with the North Andover PD, so likely a friend of Kelsey. No, but it seems like, Mastad, in my opinion, everyone who works for the North Andover PD has sided with Justin over Kelsey. They told him it would be okay for him to go break into the house to get his stuff. Why was Michelle able to call there and talk to Kelsey's lieutenant to find out that she was there? I mean, it seems to me like they're all on the side of Justin. And remember, he did break into her laptop, right? And he did when he stole her laptop after breaking into her home and brought it to his parents' house where he connected to the Wi-Fi. It has been spoken, it has been said, log into her medical records. You're right. You're right. Immediately following mother's Section 12 hold, the town manager of North Andover permitted the father to take voluntarily paid leave for a month, approximately a month, so he could stay home and be with mother and the child. During that time, the father was home 24/7 and was the child's primary caregiver. And he says, here he goes again. Mother also asserts she's in the care of mental health providers. He says we don't have any of her records. And then he goes on to say, mother has a long history of mental health issues, and it is entirely unclear to the father and the court what her mental status is and what treatment, if any, mother is currently receiving or has received since June 30th, 2025. She just told you in her papers, and she swore to it. Footnote 5, which is here. As mother testified under oath at her criminal trial approximately 1 month ago, mother held a gun to her head and pulled the trigger with the intention to kill herself, all while she believed the child was just downstairs. Footnote 5 says, at the time that mother pulled the trigger, the child was just outside of the residence with father's sister, Courtney Elayan. All right, you're bringing your sister into it too. Then he goes, footnote 6, he says, well, I don't know what kind of treatment she's getting now. He says, in December, I served her with interrogatories and I asked all about her medical records and her conditions and her treatment and everything. And she said she'd provide it once her criminal trial was concluded, but she hasn't provided any supplementary interrogatories. And her criminal trial ended on March 26, 2026. Then she says, mother has acknowledged the impact her postpartum struggles has had on both parties. In fact, mother wrote the father a handwritten letter, which, upon information and belief, was written around the time that father sought and obtained the 209A abuse order. Why would you think it was dated? It was June 30th? That explicitly acknowledges the impact that her postpartum struggles had on both parties. Is that the one that he stole off the refrigerator? When he was, tampering with evidence? When he broke into the house and stole that letter off of the refrigerator? Oops, dropped my pen. Mother acknowledged in the letter that she had been using the father as her personal punching bag, that she was aware that her actions have caused the father undeserved pain and confusion, and so she has taken her anger out on father, and the father is the most patient, amazing man she has ever met. So why'd you steal the letter? If it was good evidence for you, why'd you steal it? I don't know how this is any different. That's a great question. The letter on the fridge was from Justin to Kelsey. Okay, thank you. Right, saying what a great mother she was. Right, he's still the one saying that she was a great mother. Cool, cool, cool. Oh, yes. Prior to the child's birth, he begged her to go to the crisis center to seek help and personally went with her to all of these appointments. There's nothing different in here. Let's see if there's anything different in here. Yeah, he says, as I already told you in my first set of papers, mother unfortunately has a long history of threatening to harm herself and others and has inflicted physical harm on father and several other identified individuals over the last couple of years, both before, during, and after her pregnancy with a child. Okay, let's call them all in. Let's cross-examine them and let's see who's telling the truth. Because Michelle said a lot different things under oath at her deposition than you said that she said in your papers. Oh, he says here, however, mother's mental health issues, this is footnote 7, mother's mental health issues span before, during, and after her pregnancy. However, upon information and belief, mother was diagnosed with antepartum psychosis. Father only just recently received a copy of this letter after the conclusion of mother's criminal trial. She explained all this stuff. Prior arrest, 1 in 2018. Some other assault against a boyfriend. She said none of that's true. Physically assaulted 2 of her former boyfriends. Let's name them. She already denied that she tried to take her own life in high school. And again, all of this stuff, bridesmaid Michelle, 110 miles an hour. We heard all this. What's new? Tell us something that you didn't tell us in your first papers. Wow, man. I hope that they didn't charge you too much of this, because it's just a regurgitation of your initial papers. Yeah, she threw stuff. She broke glass items. She kicked him in his genitals. I don't know. Oh, yeah, right. And then he said she held a knife to her stomach while pregnant and to her head while pregnant. All the things that he already said that she texted, and then the baby rolled off the bed, and then she screamed at him in front of the child and the bachelorette party, and she's going to take him far, far away for a long time and all of that stuff. And he says that he unequivocally denies mother's accounts of the events in Bethel, Maine during the weekend of June 28th, 2025, and at their combined bachelorette party. She ran into the woods, and there's a police report from the Oxford County Sheriff's Office. Oh, this is interesting. This is new. Paragraph 37. It also should be noted that following the incident on June 30th of 2025, whereby the mother suffered a gunshot wound to the chest while being served with the 209A abuse or prevention order, the DCF, Department of Children and Families, opened a case and supported a finding of neglect against the mother. Oh, that's so cute. How did the DCF get involved? Who called them? How would they support a finding of neglect against the mother without ever speaking to the mother? Because the mother was fighting for her life in the hospital and then in jail? The case was ultimately closed based on the father being awarded custody and the mother having no contact with the child pursuant to the terms of a 209A breach. Oh, yeah, right. So DCF just closed their file because you got custody. You got temperate. This is just ridiculous. Oh, here you go. Further, mother's assertion that she is clean and drinks no alcohol is curious, especially given the fact that mother was recently observed drinking alcohol at a restaurant in Newburyport, Essex County, Massachusetts. Really? Do you have people following her and taking pictures? Really? You got receipts on that? I think asked Dad, who says that in Massachusetts, DCF doesn't have to speak to anyone. They can rule based on their social workers' findings based on who they did speak to. It's a weird system. I don't like it. Okay, good. That's another way. that the system is broken in Massachusetts. Just one other way. Yeah, Steve-O says, why wasn't DCF present when they took her baby? I guess they don't have a policy on that. Where was Crystal Clooney then? Is she now in cover your ass mode because she was supposed to be there and she wasn't? Oh, and then he's going to go on and on about her history of abusing alcohol, but apparently he's got people following her. Oh, mother has been a drinker for so long because sometimes we've had to leave social gatherings early due to mother's excessive intoxication. The mother threw herself on top of the father while he was operating a vehicle, nearly causing an accident and punching the vehicle's radio. Father having to pull over on the highway so the mother could vomit. And at least on one occasion, the mother becoming severely intoxicated, but they don't say severely, they say severally intoxicated, severally. After having only one drink with a friend at a bar, causing her to vomit. I don't know, maybe she got roofied, dude? Is that possible? Father had to pull over on the highway so she could vomit. Was she pregnant? Was she having morning sickness? Raise your hand if you've never had to vomit and made somebody pull over the car. Raise your hand if that has never happened to you. Anyway, in any event. At any point in your life that you have never asked someone to pull over, including an Uber maybe, because you had to throw up. Yeah, again, no hands in the chat. I have 2 words, says Carol. Cooking wine. Oh, and then she says she drank more if the child was more. Yeah, again, you put all this in your initial paper, so what's new here? Remember, your lawyers get paid every 6 minutes. Oh, I think this is new. Tell me if this is new. On or about, oh, no, this is not new. June 25th, he says he found her completely intoxicated, unconscious, and naked lying on the floor between the couch and the coffee table in the living room. He carefully lifted her onto the couch, dressed her, and covered her with a blanket. Shortly thereafter, father heard the baby crying upstairs, so he went to check on him. After the baby fell back asleep, father returned to the living room. Mother was once again naked and passed out on the floor in the same area. That was on the 25th. And yet, Justin, you thought it was a really good idea to not call off the bachelorette drinking fest 3 days later? Really? Really? Some people like to sleep naked, right? But you didn't cancel the bachelor. You were so concerned about her drinking problem that you continued and did not cancel your big party for 3 days later. Right. Somebody said, did she pass out after nursing? Great idea. I mean, great point. Father vehemently denies mother's allegation that father has or had ever had an addiction to alcohol or has used non-prescriptive drugs. Yeah, right. She said he snorted Adderall and he knew how to get it. She even named his cousin who used to get it for him. He says he underwent 2 hair follicle tests and is tested negative for all substances on both. Okay, great. Father has never drank alcohol during working hours, never suffered from shaking due to alcohol withdrawal. Why can't the both of you just STFU and agree to 2-2-3 custody? How about that? Instead of dragging each other through the mud, she's got to stand up for herself and she's got to clap back at him. But again, here he goes with another 20 pages. Oh, here's some Venmo screenshots to the father's Venmo from his cannabis dealer to Robert Moore. Okay. So why don't you name your pot dealer, which he says he's not his pot dealer. He was there were 2 payments in $10 and $15. You think Robert Moore wants to be involved in this? Robert Moore was the bartender at the wedding and he had a Venmo QR code, so they tipped him. You think Justin tipped this guy $25? Has nothing to do with purchasing cannabis. It was just merely tip money. That he's going to address the Adderall snorting in Christmas Eve 2024. He says it never happened. He worked at 24. He wasn't even present at his parents' house. Oh, child is flourishing. How dare she paint me in a negative light? Oh, paragraph 49. Father also vehemently denies ever breaking into the property located at 125 Phillipsburg Road, North Andover, Essex County, Massachusetts. There's video of you breaking the door down because the locks were changed. 2, removing any of mother's belongings from the North Andover property. 3, ripping out and or damaging any surveillance systems. 4, removing evidence, in quotes, air quotes, evidence from the property. 5, wiping and or accessing mother's laptop or iPad. 6, stealing cash and or gift cards. And 7, accessing mother's social media accounts, email accounts, bank accounts, pension accounts. Father does not even know mother's password to these accounts. Oh, he's going to explain it away now. On July 3rd, 2025, when the father entered the property to retrieve his own personal belongings and the child's, he only did so after seeking advice and permission of the North Andover Police Department. Guess what? Permission is not theirs to give, sir. You've already been to court by then, at least once. You know how the system, how it operates. You know how the system works. Go back and get a court order to get your stuff. Further, when he was gathering his belongings, he was accompanied by not only North Andover police officers, but also mother's father. All right. And that, yeah, right. Then he says, Officer Marcos' police report says, he was hugging it out with Kelsey's dad. They have no standing to grant permission. We heard the recordings. Justin and Kelsey's dad embraced in a hug and had an emotional conversation, which ended with mother's father stating, "It's not your fault. She's sick. She needs help." Great. Call into the stand. Oh, he's going to use this to his advantage. Look at 51. The father was never arrested or criminally charged in connection with his entry of the North Andover property on July 3rd, 2025, as the Commonwealth found no good faith basis to file charges against him. Oh, that's right. Footnote 11. See id, which is the Commonwealth's motion in limine to prohibit questioning. Right. In open court. In open court. Was it Gubitosi? Remind me who the prosecutor was. Gubitosi said in open court during a pretrial motion hearing. By the way, we're not going to charge him with anything. We don't see any evidence of any crime. By the way, and also, like if he takes the fifth, we'll just immunize him. Yeah, that's what they said. It's exactly what they said. We'll immunize him. No big whoop. He knows he's protected. By all accounts, he says he was a resident at that time. I can't. Doth protest too much. While the father acknowledges that he listed his parents' address as his current residence when he applied for the 209A abuse prevention order and filed the instant 209C matter, it should be noted that the father was not represented by counsel at the time, and he was handling these matters pro se. I mean, of all the people in your family that know so much about the court system and how to get people involuntarily committed and stuff, that they didn't know a lawyer. And his footnote 13 says father reasonably believed that both parties subject to a restraining order, could not share the same address. Mm-hmm. 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 Yeah, I've got canceled checks, all the things. Talking about the $5,000 again. Uh-huh. Yeah, deposited a check from his grandma dated December 26, 2025, $5,000. It was mine to take. My grandma gave it to us. That was before the baby was even born. And here's all the stuff that he said before about getting the refund from travel. Oh, he fully funded the honeymoon. He fully funded the honeymoon. So he wanted to take his money back. He was able to obtain a refund for the Airbnb he rented, but the flights were non-refundable. So it was okay for him to take all the money back from the travel company. Thank you, Mastad. It says no judge will take any of these documents seriously. Mudslinging gets litigants nowhere. I know. That's why I think it's so gross that he's doing it. He produced their bank statements in discovery. All that I'm doing is protecting my child. That's all I've been doing. I've been sending her bi-monthly updates. I've been sending her photos. If they ask me any specific questions, if her attorney asks me anything specific, I'll give them answers. I did allow Kelsey's sister Madison to attend the baptism and to record the ceremony. And 3 days ago, I let Kelsey see the baby, supervised by my lawyer. Notably, the father voluntarily proposed and facilitated this visit without the need of a court order or formal written agreement. Look, Judge, look, I offered. It was my idea it was my idea that I let her see the baby. That was my idea. How good am I, Judge? Let's see what he says about our family wizard. He doesn't like the step-up plan because it's inappropriate, too rapid, and given the facts and circumstances of this case, not in the child's best interests. And yeah, the child has not been in the mother's presence since he was 4 months old, except for the one time that I suggested that she be allowed to see the baby at my lawyer's office, Your Honor. And then he says in his footnote, it should also be noted that the father objects to using Mrs. Jean Tinney, social worker, as proposed by mother, as the parenting supervisor in this manner. It is the father's further position that he continue to have sole legal custody of the child at this time until further agreement of the parties or court order. I mean, Your Honor, I let her see the baby for 2.5 hours. That was my idea. So, but now I want to have sole legal custody until either we agree or the court orders. Who knows how long this court order could take? Everyone knows how slow family court is. He doesn't even mention the Our Family Wizard stuff and how he failed to, or how he blocked her. And this is what he wants. Everything that he said before, he wants it all. He swore to it. He signed it today after this was filed at some point, and his lawyers filed it. And it's really not a lot more than he's already told us, except for he told us that it was his idea and he volunteered to allow her to see her own baby that she hasn't seen since he was 4 months old, right? All right. Well, this should be an interesting hearing tomorrow. I don't know anything about this judge. Does anybody know anything about this judge? Casey Paralegal, thank you for your super sticker. Jeannie just dancing through lightning says it's fair to say she, and then I don't know what the rest of that should say. Thanks for your super chat. Known to 3 says Rage Diamond Painting started. Awesome. I don't know what diamond painting is, but I'll allow it. Sarah B. Creative says, I love you with all my heart. I love you more, Sarah. Mama She, thank you so much for your 50 through Cash App, says, for never stopping, and we ain't got no quit. That's right, Mama She, we ain't got no quit. Why does this need to be out there? It's not good. The kid is going to see it. I don't know. I don't like it. Al dente, foster parents, are they via their rehab program? I don't know. I think they do have a foster child, or an adopted child, but I really don't have any details on that, and I don't know. Thank you. He got medical records when he sold her laptop. He claims he didn't. He doesn't know any of her passwords, he says. He's denying it all. Thanks for being here for 5 months. Thank you, Mama She. I love you so much. Diamond painting is so fun. All right. Well, I mean, I'm going to have to go on Amazon and see what it is. Yeah, we just get sleepy sometimes, but no quit. I know my voice needs to rest, but tomorrow I won't be talking so much because there'll be a hearing. Everyone's laughing now like, yeah, really? You always talk during hearings too much. Robin, thank you. Says, thanks for keeping us updated on this by Venmo. Go abs. I said that before, right? Okay, hang on. What's happening in the game, Scott? Or did you split? Okay. Love your vibes. Ladybird loves my vibe. Thanks, Ladybird. It's an acquired taste, like sushi. Common Sense Investigations. Oh, we know you didn't know her passwords. That's why you added how to access her email to change the passwords. You're an investigator. You know these things, right? Right? We call it diamond art here in Canada. I'm hooked. I have like 6 or 7 done. I just got into it. Okay. Maybe I need a little painting in my life, maybe. Thank you on top. Tangled Charlotte says there's so much new material for a new judge to take in. I'm afraid she's going to decide not to decide. Oh, Carrie B says, is he hiding behind semantics? Perhaps his sister broke into her accounts. Oh. Thank you on top for your super sticker. You're awesome. All right, my friends, when I hit end on this stream, you are going to be sent to tomorrow's stream so that you can hit the reminder button because, as we have learned, the tubes of you have stopped sending out notifications because if you don't interact with them, they're afraid you're going to turn off all notifications. Then you won't get any notifications from them, and they don't like that. So Lola, the good dog, says, I hope her attorney asks where Justin obtained her medical records. He's using unlawfully obtained evidence against her in a custody dispute. It's vile and illegal. Mel, has she filed a police report yet? I don't know. I have no information on that. Despite what you may think, or anybody, I don't have any inside information on any of these cases that I cover with you. None. Not a one. I read what I can obtain through public records and otherwise, I don't have any idea. And thank you, Chaos Granny. Kansas Granny has been here for 5 months. I love you guys. I love my moderators so much. And just to let you know, like if you write me an email complaining about my moderators, I am going to side with my moderators every single time because without them, I could never run this channel. Okay, they keep it classy. They do what they got to do. Sometimes you could be blocked if someone's trying to mod on their phone. I do it all the time because I'm trying to press something on my phone and it'll block the wrong comment. It'll time somebody out. I'm not here to, apologize for them. They do the Lord's work. They're doing the Lord's work. So it is what it is. Music to My Soul says, I think it might be best for the judge to have a judge decide this who didn't sign the original restraining order. So I look forward to seeing how this new judge responds. Yes. Come on, Tiny Jesus. We need you more than ever, says Law Junkie. Peace. All right. Thank you, my friends, for coming to hang out with me for 3 hours and a half. Wow, that's we read like 48 pages, 68 pages in that time. So it was long. It was arduous, but we did it. Please leave comments respectfully after the show. It helps the algorithm. Please hit the like button. Do all the things. I'm going to teleport you over till tomorrow. Okay, so you can hit the reminder button and come back. Let me know if you know anything about that Wisconsin case that I told you about earlier. Wisconsin versus Josie. What was the name of that case? Josie. All right, hold on. I have to find it before I let you go, because I'm going to look into it and see if it's a short trial. It is one that we could cover gavel to gavel. Hold please. Because Lawn Crime is going to be broadcasting. It is called Wisconsin versus Josie Dikeman, Dikeman. Does anybody know anything about that case? All right, buckle up, buttercups. Stay cool, stay kind, stay classy. Don't believe everything you read on the internet. Well, be kind to each other. And I will see you hasta mañana. Okay? I love you guys. Buckle your seatbelts. Hit the reminder for tomorrow. Thank you, moderators. I love you so much. Peace.